Program will commence. Our learned president will come to the dais. And Honorable retired Supreme Court Judge, learned V.Gopal Gowda sir Garu will come to the dais. Our Honorable Second Additional District Judge. I request Additional Senior Civil Judge to present bouquet to Honorable Justice. I request Principal Junior Civil Judge Garu to present bouquet to His Lordship. I request Ramesh Garu, Special Magistrate, to come out to dais and present bouquet to His Lordship. I request all the advocates to take your respective seats, please, and listen to your Lordship. Now the senior advocates will present bouquet shawls to His Lordship. Sri B. Naresh Kumar Reddy, member of our association, ex-MLC and ex-municipal chairman, will present shawl to His Lordship. So now I request our member Azizullah Pasha Garu to introduce chief guest to the gathering.
morning to you all. In brief life history of our Honorable former Judge of Supreme Court, Sri V.Gopal Garu. He born on 6th October 1951 in Chikballapur, and he studied BSc in Chintamani and he did his LLB in Mysore University. And he practiced, and he is the son of Sri Gowda Garu and Subbamma Garu. He joined as High Court Judge in Karnataka 1997 to 2010 and Chief Justice as in Orissa High Court from 2010 to 2012. And he was elevated to Supreme Court as Judge 2012 to 2016. Peaceful life in Petheru. This is what I gave his brief history. Thank you, one and all.
So now I request His Lordship to deliver speech. And this topic is the Indian judiciary independent under the Indian constitutional framework, work experience. I request His Lordship to deliver.
Respected the President of the Madanapalli Bar Association, Mr. Ramannath Reddy, another respected General Secretary of the Bar Association, my brother judges, Additional District Judge, Civil Judge Senior Division, Junior Division, and Special Judge who are present here. The Executive Committee members of the Bar Association, senior members of the Bar, young members of the Bar, my sister lawyers who are present, not in large number, sizable number. Most of them are newly entered into the bar. Happy and good sign for empowerment of women. Don't confine yourself to the court halls. Please look towards the rural folk and empower the women who are in 50%. Only in robes you cannot do justice. Outside the court you are required to do justice. Members of the staff, at the outside, congratulate, give my greetings to each one of you are present on this important Republic Day celebration. This is 77th Republic Day celebration. Written
Constitution, which we accepted on this day, 26th January 1950. We became republic. We are being governed under the provisions of the Constitution of India, which is a political document. It's not what I am saying. This, I have borrowed the phrase coined by the 9-judge bench of the Supreme Court of India in the famous historical judgment in S.R. Bommai vs. Union of India, while examining the correctness of the resolution of the Legislative Assembly of Karnataka State. We became independent 15th August 1947. Constituent Assembly was established not on the adult franchise, but on the basis of land holding, nominees of the monarchs who were ruling more than 600 princely states of India. Freedom movement leadership was given by the lawyers, the father of the nation, Mahatma Gandhi, the barrister at law, Pandit Jawaharlal Nehru, the first Prime Minister of the country, Rajendra Prasad, the first President of India. So many people joined the freedom struggle. Millions of the people sacrificed themselves to liberate the country from the colonial rule. The Britishers came as business people. They ruled this country more than 200 years. It became very difficult for the people of this country. When we became independent, our population was 39 crores. Today we are 143 crores. In the world, the Asian continent, after the people democratic country China, the Communist Party ruled country which is the strongest next to the imperialist country America. China today dictates terms with the imperialist forces of the world. So China is first populated country, highly populated country, second in Asian continent. We stand second, 143 crores as of today. China, the difference is the people's democracy there. In India, it is parliamentary democracy. The parliamentary democratic system of governance of the people of this country. There is a vast difference between people's democracy and the parliamentary democracy. I don't want to go into that aspect of the matter. I must come to the topic. The topic chosen by the bar is very interesting and very relevant topic from the viewpoints of the lawyers. Your role, again, according to me, second independent struggle, you must take the lead. That is the situation today in India. despite the fact separation of powers is contemplated under Article 50 of the Constitution of India. Under the constitutional scheme, three organs are very important. Fourth organ is also there. Friends from print media must be here in large number. The media is the fourth estate of the state. They are the watchdog. They have to protect by exposing all evils from all the organs, including the judiciary. That's very much important for the good governance of the people and the Constitution. I am very happy to be in your midst today on an important Republic Day celebrations in the Bar Association. I saw while coming from my place, Bangalore, left side, the district administration is also organizing to celebrate the Republic Day. Our people are living happily or not, but some not sizable people are participating in the celebration of the Republic Day. We have got our own problems. We have got unemployment. We have got starvation. We have got poverty. Despite all these evils, we are remembering to celebrate an important day, the Republic Day celebrations. That shows our patriotism towards the country. Patriotism is very, very important for every one of us. The second happiness for me, this place is not new place for me. From here towards Bangalore, my mother place, Srimati late Supamma, hails from Chigalabailu village. I used to come to this place along with my grandfather, Motumakal Subbareddy. I cannot forget. I have spent my boyhood days. Each one of the tree here, each one of the stone building here, the road. One Qasim Sahib was the tailor just opposite to this place. I used to go to his house. My grandfather used to bring me here every Tuesday, this Sunday day. I remember that. I have not forgotten this Madanapalli. Each gully I know, each person I know, each family I know, lawyers I know. That's why I accepted this invitation to Madan Mohan Reddy, who is my close friend, hails from this taluka. I accepted the invitation. Normally, very rare, either a retired judge or a sitting judge going to a taluka place to address the gathering. Day before yesterday I was in Bhubaneswar. Yesterday I was attending 3 functions in Bangalore. I had number of invitations in big education institutions and other places at Bangalore. I choose to accept the invitation of Madanapalli Bar Association because my affection, my love and my commitment to this place, because my mother hails from this taluka. So I am also belong to this Andhra Pradesh. I made a statement in Amaravati. I have got interest in this state. Telugu చాలా బాగా మాట్లాడగలను నేను. తెలుగులో నేను మాట్లాడేదని చాలా బాగా వచ్చు నాకు. తెలుగు సంగీతము, తెలుగు సాహిత్యము, తెలుగు ప్రదేశంలో 2 రాష్ట్రాలు విభజనమైనా కూడా మంచి ప్రబుద్ధమైన ఇట్లా రాజకారణిలు, రాజకీయ ముత్సద్దలు ఇక్కడ ఇంకా వచ్చిండేవాడు. From neighboring district, Sanjeev Reddy was the president of this nation. Brahmananda Reddy was the chief minister. N.T. Ramarao, within 6 months, he became the chief minister. He became a famous chief minister of United Andhra Pradesh. Before that, great, dedicated politician, the first chief minister after the bifurcation from the Madras province. What is mean? Prakash. I read in the newspaper such a great honest man in politics. I can tell so many things about all those things. I wanted to tell about all this historical background of this state and bifurcation thereafter, what is happening, you know well. I read in the newspaper, he was sitting for waiting for a train to journey to his native place. Some officers saw him and took him to his house. Such honest, dedicated politicians were there in this country. For that purpose I mentioned the name of the first chief minister of United Andhra Pradesh. Thereafter so many politicians are coming, so many chief justices are coming, so many chief secretaries are coming and going, but they did not leave the indelible mark to remember. I'll stop this introduction only for the limited purpose. Under the governance of the Constitution, the question, the subject given to me to deliberate and deliver my lecture, is the Indian judiciary independent under the Indian constitutional framework and work experience? Work experience as a lawyer, as a judge, as a chief justice and judge of the Supreme Court of India. Answer must be yes and no. Yes, for certain decades. No, the recent development which is taking place. So answer to this question, you must understand that Indian judiciary is independent. Yes, it was independent and it is also partially independent. I am going to give the classic examples, the recent developments, why I am telling this. I know what I am speaking. I am a former judge of Supreme Court. I am a part of the Indian judiciary. I am aware what statement a retired judge is making before the lawyers. I am fully aware of the position which I am holding, position which I held, and what I am speaking publicly. I am accountable, answerable, therefore I am making a responsible statement to the subject. Yes, partly yes, partly no. Now, judicial independence before the Constitution, that is 1946 to 50. Dr. B.R. Ambedkar, constitutional vision, is the architect of the Constitution. He was the chairperson of the Constituent Assembly in the drafting Constitution Committee. He had great vision, a visionary, highly scholarly person. He toiled, he struggled, Even now, today, his portrait is everywhere because of the political reasons. But we as lawyers must salute him, must remember him. His contribution to the drafting, answering the objections to each article wise in the Constituent Assembly before accepting it on 22nd November 1949, he has answered all the queries. Fantastic, very potential Constitution as given to us on 26th January 1950. The early constitutional foundations from 1950 to 1960s to one era. Thereafterwards, 1973, 13 judge constitution bench in Keshavananda Bharti, 73-4 SEC. You have to read. Earlier to that, 1951, Shankar Prasad's case. You have to read constitution bench. Later, 1965, Sajjan Singh case on the aspect of the independence of the judiciary. 1967, the judgment is, please stop the giving tea, please. So don't interfere now. You can give tea afterwards. No, don't give tea, no. 1967, Golkanath's case, 11 judge bench. This also deals with the amendment power of the constitution by the parliament. 1973, the power of the constitution, the parliament, under Article 368 of the Constitution of India. What extent is it a limited power or unlimited power for the parliament to amend the constitution? 73 has opened a Pandora box and said, you have no business to amend the basic structure, concept and theory was propounded in Keshavananda Bharti's case. I request the youngsters who are present here, you are the learned members of the bar and also the judges, learned judges. It is not used merely because of the phrase is required to be used. Learned and honorable judges, learned lawyers. The nobility lies in the learning. That's why in the entire universe, it is only the lawyers are called the learned persons. Of course, in the judgment we attack the judgment by the civil judge junior division in the first appeal, learned judge is error. The learning must emit from you. For that purpose, merely phrases are used, learned is not sufficient. You must acquire that knowledge. Learning is a continuous process. It is not stagnated. It will not stop. It is a continuous process. So therefore, all the judgments, how the evolution had taken place over a period from 1951 to 1973 and 1980 regarding the independence of the judiciary. If you see its aftermath of the judgment, the step in of the parliament, amendment to the constitution, and the action of the then prime ministers in more superseding the judges from appointment or seniority to the Chief Justice of Supreme Court of India, is history. So therefore, I said, sometimes if you are strong enough, even in the court, I want my lawyer friends to be strong before the court. I want independent bar. I want a strong bar. A strong bar can make a great institution. It is the institution is not exclusively meant for the judges. It's meant for the people. This is what has been said in 94 Supreme Court. Famous Chief Justice Bhattacharya case went to the Supreme Court. 94 is reported. The judiciary is meant for the masses of the country. That's why the contempt proceedings. Contempt proceedings against, it is not for the fancy sake. Nobody irresponsibly behave, attack the judiciary. Judiciary means only not judges. Judiciary means both judges and the lawyers. It is the lawyer's contribution for evolution of law, right from 1950 V.Gopalan's case. So, I deviated. I wanted to tell the members of the bar, more particularly any members of the bar, to read these judgments from tomorrow. You have to burn your midnight oil, not as a only student. A lawyer is always a continuous student. Please remember this. Lawyer should not say to any client that you have no case. I am not saying you should take up all frivolous cases, no. Vexatious cases filing, no. No, don't say a judgment of a court, a trial court, first appellate court, second appellate court, and civil appeal in the Supreme Court is not the finality. It is final because finality is provided. But every judgment, there are grey areas are left by judge and the judiciary. Therefore, always binding precedent under Article 141 is binding till it is decided on the questions that arose, argued, considered and rendered the judgment. That is what is said in 11th Judge Bench in 1971 Supreme Court, AAR page 511. Madharao Sindhya's case. This is from Madhya Pradesh. He was a prince. Madharao Sindhya's case, AR 1971, page 511, paragraphs 271 to 273. Please read it. What is binding precedent? So I am on the point that every judgment is not, may be correct to the facts, the evidence, appreciation, consideration, and recording a finding. Don't say to the client, you have no case. You have to study, you have to make research, you have to apply your mind. Any grey area is left by a judge or a court in that judgment. On that question, you are required to apply your mind. So for that purpose, you are required to read the judgment. Now, S.R. Bommai is also very important versus Union of India, 94 Supreme Court. This judgment, Supreme Court examined the power of Article 356. What is the power of the imposition of a president rule on the recommendation of a report submitted by the governor, the executive head of the state, and now it has become very controversial now. So, Tamil Nadu, Andhra Pradesh, it may not be happen, Kerala, the latest is Karnataka. Governors are refusing to read the speech that is prepared by the Council of Ministers in the cabinet. So that has also become a controversy now. That indicates that the constitutional functionaries are refused to function with the keeping in view the object and intent of the constitutional mandate and Article 176 insofar as the governors are concerned. Governor has no role to play to incorporate his statement there, no. Governor shall read either in the first assembly session after government is established, first election after the election, then afterwards every first assembly session which is convened, he shall read the statement. Only on that point I will say. So S.R. Bommai is very, very important case. They laid down the parameters. Supreme Court in the year 1994, after any government, either this political party or that political party, UPA or NDA, is immaterial. The independence of the judiciary is very, very important for overseeing the good governance of the people, to check the functioning of the legislature, to check the functioning of the executive. Therefore, the separation of powers under Article 50 of the Constitution of India is very, very important. Therefore, to check the functioning in enacting the law, from the entries list 1, list 2, list 3. List 1, the parliament. List 2, state legislature. List 3, both parliament as well as the state legislature. Concurrent list. So, what kind of enactment you enact in exercise of your legislative power under Article 245 of the Constitution of India is very important. So one judge, look at the stamina and the strongness. Article 356 report was sent to the President of India. By that time, there were a number of, during 1977, after the defeat 1977 election, after 18 months of emergency, during the then Prime Minister Srimati Indira Gandhi, Janata Party came to power. Morarji Desai was the Prime Minister, the then Prime Minister. 14 states were duly elected governments were dissolved. Just like that. Then this case referred to the larger debt, S.R. Bommai's case. S.R. Bommai from Karnataka state, threadbare, they examined the power of the governor, power of the president, and whether how duly elected government, sovereignty given to the representatives, Sovereignty is the basic structure of the Constitution. In the preamble of the Constitution, if you read the phrases, sovereign, socialist, secular, democratic, Republic India. Sovereign, socialist, secular, democratic Republic India. These phrases are very, very basic structures. Democratic, today the debate is going on in the entire country. SIR, Supreme Court matter is being heard. Nothing is happening. There, independence is there or not, people are watching now. Independence of the judiciary is there or not, watching. When Election Commission 324, a constitutional functionary meddling with the constitutional right of the adult franchise of 18 years old people can exercise their power or not is the subject matter of a controversy today, SIR. So democratic Republic India, democratic is the basic structure of the Constitution. Please remember, please lawyers, mark it. Whether democracy is there or not, democracy is completely curtailing by the executive and the constitutional functionary. When it is being curtailed, the independence of the judiciary is still the backbone, the stamina is there to examine or not is the test for the Supreme Court today. 65 lakh members are deleted. 55 lakhs in Calcutta. Again 55 lakhs voters are removed from Kerala. 3 crores and odd in Uttar Pradesh. Adult franchise is not a simple right given. Adult franchise is a constitutional right to elect their own representative, giving sovereignty to enact the law. Enact the law, keeping in view the constitutional philosophy. What is constitutional philosophy and the concept? The constitutional philosophy and the concept is socialist. This is by way of 42nd Constitutional Amendment. Amended to the basic preamble. Before that, in Keshavananda Bharati's case, Supreme Court has said, Keshavananda 13-judge bench, constitutional bench, Indian constitution is a socialistic, egalitarian system of society. That is the conceptual idea. In the absence of amendment and bringing the word, the socialist, to the preamble, Supreme Court 13 judges, 7:6. 7:6 is not absolute, the majority judgment. Thin majority of one judge decided. Golkanath case is the correct position. Unlimited power is not their parliament. You have got only limited power. You cannot touch the preamble of the Constitution. That is the strongness of the Constitution given by Dr. Ambedkar. So therefore, look at this, the rule of law, rendering justice. The word used, render justice. You are not giving, you are rendering, you are required to render justice. Judges must understand, we have to render justice. It is not a charity, it is a constitutional duty of a judge. Either the trial court, appellate court, high court or Supreme Court. You are bound by the oath of office under the Constitution. So therefore, you must remember, the strongness lies if the bar is strong. I wanted, a bar must be strong. That does not mean have confrontation every day with the law judge. No. Confrontation will not do. Your knowledge must emit, tell the judge, enter into his brain. that here is the injustice, here is the justice you are required to render in a case. That is the strongness. A strongness, wherever the strong bar is there, strong judiciary will be there. Therefore, you are the defenders of the Constitution. That's why this topic is very relevant. I accepted your invitation. I wanted to tell and rouse the members of the bar to take back you to the freedom struggle, and you have to take the lead today to correct it and protect the Democratic Republic India. That's why I came here, Mr. Reddy. Not just like that to deliver a speech. I am before you to tell my countrymen, tell my brethren and sister judges, lawyers, that country is facing turmoil. You have to protect this institution like your baby protecting a mother protecting a baby. Otherwise, serious, the roadblocks are going to take place in future. The Bommai case, there are two important aspects. In this case only, Constitution has been said it is a political document. The politics, if you mention the politics, people say, no, we don't want to go to politics. Who do not have the politics? What do you mean by politics? You should not have aversion to the politics. Politics is a great subject. Without understanding the politics, can you live as a human being on this universe? Is the question. Politics means human science. It is human science. So therefore, don't have aversion. Of course, there are aberrations going on. Now, because good people are not there. You have to go there. Ambedkar is not there. Mahatma Gandhi is not there. Sardar Vallabhbhai Patel is not there. Subhash Chandra Bose is not there. But there are Subhash Chandra Bose, Ambedkars in our country today. Yeah. They're not there. But you must grow. So, on the point, yes or Bommai, political document, every ideology is the socialist. The concept of secularism in a multi-religion country, it is not one unitary religion. It is a multi-religion country. All religions are equal status. There is no major or minor religion in the concept of Indian Constitution. All religions are equal. Article 14 is applicable. This is what Supreme Court has said, not me telling. It is what Constitution says. So don't say, this is major religion, you are minority religion. There is no concept of minority and majority under Indian Constitution. If you read carefully Article 25 to 30, you understand this. So therefore, Supreme Court in S.R. Bommai's case, 9-judge bench, elaborately laid down the procedure that under what circumstances duly elected governments can be dissolved. People give mandate for 5 years. You may not the majority of members to support your government. That must be tested on the floor. Without testing on the floor, that's what the principle in S.R. Bommai's case. So therefore, the report is no longer a secret document. A governance report under Article 356 will be submitted to the President of India to accept it and place before the Parliament. Parliament must pass, both Parliament as well as Rajya Sabha. Then only the recommendation of the Governor will come into effect, resolution of the Assembly. So report is a public report. You must disclose the report, what reasons you are recommending to the President of India for resolution. That is the independence of the Indian judiciary in Bommai's case. He holds the field today. This is what exactly said in Maharashtra's case. And Chief Justice Chandrachud was there. He said, you should not have convened the House. Duly elected government was in power at that time. The Maharashtra something like that. Split of some political party that Ekanath Shinde, he went there. He submitted a government has lost the majority. That should be tested. Then only you must call upon the other political party to form a government. That did not take place in the Maharashtra government. This is what Chandrachud said. Having said so, he did not set aside that government coming to the power. This is what NDT Achar, the parliamentary secretary, has wrote an article in the Hindu newspaper. That having said so, why did he not interfere in getting the new government formed? The summoning of the House itself by the governor is invalid, unconstitutional. In view of the judgment of the Bommai's case, why did you allow the government to form? Taking the split members from the, what is that party in Maharashtra? Shiv Sena. How can it happen? This is what Chandrachud said, the then Chief Minister. But he did not proceed further from there to say this not duly elected government. He should have said, I would have said that. That is the negative aspect. There you have got the independence to say so. To give the consequential order, you did not do so. So therefore, the independence is deviated negatively there. Is the public criticism. Now, after 94, before that, Delhi Judicial Service Association was the state of Gujarat case is there. I am coming to that point. Maneka Gandhi's case, after emergency, this Maneka Gandhi's case, Passport Act. Maneka Gandhi, you know that she was the daughter-in-law of Indira Gandhi. 77, Janata Party came. They wanted to impound the passport of Maneka Gandhi. Maneka is not Menaka. Please don't misunderstand. Menaka is Vishwamitra. There. This lady is a Maneka Gandhi. So she questioned the constitutional bench. Please read the judgment. The beauty, not beauty parlor, the beauty of the judgment in this, if you read Maneka, Article 14, Article 19, 14 equality, arbitrariness, reasonableness, justifiability, in the absence of a statutory provision, following the principle of Adi principles of natural justice. In this case, Supreme Court has propounded executive action or administrative action to impound the passport of Maneka without giving an opportunity complying with the principles of natural justice. Every day in and out you will be arguing before the magistrate and civil judge. Violation of the principle of natural justice. It may not be here, but it may be in the constitutional courts. Every day lawyer coming and telling that violation of the principle of natural justice adi altram patram. The principle is Bentley's case. The origin of adi altram principle is Bentley's case, Dr. Bentley's case. There, the concept is any action entails civil consequences or criminal consequences. Compliance of principle of natural justice is a must. This is what has been said in Bihar SIR case, Calcutta SIR case now, Kerala SIR case is referred to the constitutional bench now. That is going to be heard recently. So, The principle in Maneka Gandhi's case, 1978 Supreme Court page 597, paragraph 57 is the most important paragraph. Please read this judgment, 1978. And this case Puttaswamy, Justice case Puttaswamy versus Union of India, right of privacy is a fundamental right, read into Article 21 of the Constitution of India. So what a beautiful propounded the theory by the judges. Judges, they propound not just like themselves. It is because the concepts which will be propounded, the ideas, the original idea will be presented by the lawyers. It is the lawyers, the contribution most important. That's why lawyers must assess the bench or a judge, or in that case, throw light that this is the law, these are the facts, this is the legal consequence that will happen, please do justice. So therefore, this case, Puttaswamy's case, of course, 1968 there was a judgment. This case, Puttaswamy's case, is a famous case of Aadhaar card. Aadhaar is required to be, is it not violation of Article 21? Why should I give all my personal data to the government? It will be available, they may do anything, they may harm me. So therefore it is in violation of Article 21. Right of privacy is a fundamental right. It has been read into Article 21 of the Constitution of India. So this is once again this case, Puttaswamy's case is very important because ADM Jabalpur during emergency, 1976 Constitutional Bench, in that ADM Jabalpur, only dissenting voice is Justice H.R. Khanna. Only Khanna's portrait in the second photo hall, he demitted his office by resigning. His photo is there, no other judge photo is there in the Supreme Court. Do you know why? He lost his Chief Justiceship because he contributed, he gave a dissent judgment in ADM Jabalpur. Now please understand, if you argue well, if you defend the accused, defend a poor lady, I may lose my judgeship. I may lose cases because judge may have a prejudice. Look at H.R. Khanna. Khanna, the great stalwart and the great jurist, a courageous man, he has lost his Chief Justiceship of Supreme Court of India. He is the person who gave the dissent. His dissent voice is the judgment today in case Puttaswamy's case. That is 7-judge bench. The Chandrachud father heard in the judgment during emergency. The later Chandrachud, his son Chandrachud, disagreed with his father, ADM Jabalpur. ADM Jabalpur is no longer the good law today. That is, during emergency, preventive detention, fundamental rights are not there. Therefore, you can do anything, everything. The police can do, detain, cannot be questioned. All these things had gone into the winds after case Puttaswamy's case, 2017. Thereafter, Shreya Singh versus Union of India. I am going to present all these aspects. power. You understand? No political party in power. Appointment of judges should be controlled by a political party. Only merit, integrity and independence should determine judicial elevation. I am presenting this statement, not my statement. The first Chief Justice of India, Supreme Court, he made a statement. This statement you put to the present context. What is happening? Either appointment, elevation, is independent, is on merit, is the person who has got integrity is being considered. Is the million-dollar question today. You are required to test the independence of judiciary is still strong. It is still there. In the test is the selection process, the collegium system. I am going to relate to the recent development. I am going to present it. Politicization would destroy public confidence in courts. Politicization would destroy public confidence in courts. You must have seen what happened in the house of the Chief Justice. Maybe a religious function. It became the highest, the Prime Minister went there. It is not a social function, it is a religious function. But what did he do? It was publicized. Why you publicize? What is the background behind it? I am only giving an illustration. So therefore a judge and also a lawyer. Yes, you may be affiliated to a political party. There is nothing wrong. But a lawyer doing that, when you conduct the case, argue the case, you are in robes, you are before the court of law, you are an officer of a court. You must remember that. You should not bring your political ideology into the case, and so also the judges. Your predilections, your understanding of men and matter, the religion, the caste, sub-caste, isms, only concept is constitution, but not your own predilections. You may like it, you may not like it. That's a different aspect matter. So therefore, politicization, the political document, if you do it, permissible. Politicization is of this religion, is of this caste, render judgment. That is not independence of judiciary. That is not permissible. You are a judge. You judge case and merits. Perception, your perception you incorporate it. You may strongly believe, but your belief should not be put into the judgment. That is not a judge. This is what exactly Supreme Court has said in V.Gopal's case. Please read this judgment, paragraph 32, AR 1986 Supreme Court. V.Gopal. Correct, Mr. Uday? 86 Supreme Court, page 180, paragraph 32. This paragraph 32 is the life includes livelihood, etc., etc. But paragraph 42 or 48, Supreme Court says, the moment you prejudge a case, you are not a judge in that case. Without hearing, without knowing, if you are expressing your views, you have predetermined Therefore, you are not a judge, you should not hear that case. That is the principle. That is because the independence of the judiciary. So therefore, please remember that politicization and predetermination or perception, your political ideology to incorporate into a judgment, apply the judgment, that will be destroying public confidence. No lawyer, no public. You may have an impression you are doing your job, but public will be watching. Lawyers will be telling. Your stone in the building will be repeating what kind of judgment is being rendered here. So stone will speak, the window will speak. Lawyers may not speak. The people will speak. This is 100% sure. I am telling this, my experience I am telling. This is what, please remember this. I retired as a Chief Justice from Orissa. I was there for 2 years, 9 months. I am still relevant in Orissa state. People trance if I go there. Every university, every bar association, every household name is Justice Gopal Gowda. Why? I love the people, I respect the people, I render the judgment impartially. That's why they remember me. I wanted my brother and sister judges and my lawyer friends must have that kind of the character. This is about L.L. Kanian. This was not rhetoric, it was constitutional foresight, is what he said. These aspects are constitutional foresight. The judicial memorandum of the Constituent Assembly, I told you Constituent Assembly, nearly 100 High Court judges wrote memorandums to the Constituent Assembly warning against the three aspects. Executive dominance over appointments. Yes, collegium, the people are telling, the ex-vice president also telling, overstepping, judiciary is overstepping, the sovereign function will rest with the parliament. This is what Keshavananda Bharti is not relevant, he was talking all these things, no. But the collegium system, the High Court judge 5 members, the Supreme Court judge 5 members, High Court judge 3 members. And this process is for the first time in Judges Association case they said. That is because it is exclusively a judge and a lawyer will know who is who, what is he, what is the background. Your bar knows everybody here, every lawyer. A judge from this bar in the High Court will be knowing what is the antecedent of this judge. A judge from foreign state coming here, watching, telling, he will not be knowing his background, his social background, his parental lineage. He will not be knowing. So therefore, if that is not permissible, the executive dominance over appointments also impermissible. You should not. That's why the NDA case, NGASC case, Supreme Court has said, independence of judiciary will be lost if you are allowed the nominee of the political executive are there to select, consider bar member to be elevated as the High Court judge and Supreme Court. That is not independence, because the executive dominance is not going to take place. Independence of judiciary will be lost is the case in NJAC case 2015. A replacement of regular courts with the executive tribunals. You are seeing, yes, state administrative tribunal. No, before that, land tribunals. the concept is correct. Tribunals are also constitutional functionaries. This is again 42nd Constitutional Amendment during emergency. The tribunalization today completely destroyed the strong fabric of independence of judiciary. We get feedback. There is today State Administrative Tribunal, Central Administrative Tribunal for civil jurisprudence cases, service jurisprudence cases, Consumer Forum, consumer jurisprudence, Labour Courts 1947 Act, Labour Courts and Industrial Tribunals, Section 7 of the Act, Industrial Tribunals Act. It was stopped there. After 42nd Amendment was given effect to income tax tribunals, you must have seen what happened in Jaipur income tax. Somebody telling, and he telephoned, he said not before me. One person has said not before me, but silently it is going on in every tribunal. Crores of rupees, this department people will tell. Our High Court judges who are in the committee will tell. People will tell today. So tribunalization has lost the independence of the object is good. Object is land tribunal, Assistant Commissioner is the chairperson. I don't know, here also land reforms were there. Land reforms is the case in Keshwanadabad. So there the object is, he will be knowing what exactly the position, whether he is a tiller or not. He is entitled to get occupant's rights in respect of that land or not. A seaman, woman, and these people will speak truth and come do render justice. It will not, decades it will not take place. A rape case will take 10 years, 12 years. Divorce case will take 20 years. What is the use? So, the object of establishing the family court, labor courts, tribunals, service tribunals, central administrative tribunals, income tax appellate tribunals, green tribunals, all these things are correct. But it will dominate because the executive, the secretary is there to appoint these persons. Preventive detention without judicial safeguards. This is the latest case. Preventive detention, V.Gopal, 1950. Yes, he is a threat to the national integrity. Preventive detention, MISA Act, all these things. When the workers are on strike, MISA, these people threat, give a letter. We will arrest you, put you in the jails. Political detentions. V.Gopalan's case, well for consideration, he is a present leader from Kerala state. He was a renowned statesman, political statesman. He was a teacher, primary school teacher. Please remember, he rose to the heights. During emergency, he played an effective role of an opposition party, the left Marxist party, Communist Party of Marxists. In that case, Fazal Ali gave a dissent. Preventive detention is not correct. But his dissent minority view became the majority view today. V.Gopalan's case is no longer the good law after 1963. So therefore, this preventive detention without judicial safeguards, therefore the judges, a preventive detainee is there, must give top attention, examine. Procedural safeguards provided the Constitution has been complied with. He has been given show cause notice. The language known to him. Objections are received. Has he been heard? High Court committee headed by the chairman of the sitting judge examine all aspects or not. Procedural safeguards are the substantive rights, constitutional rights, fundamental rights given under Part 3 of the Constitution. Now, 124 judicial appointments to the Supreme Court. Article 50, separation of judiciary from the executive. 125 deals with the salaries charged to the Constitutional Consolidated Fund. Judiciary helped design its own independence before a republic was born. What did Dr. B.R. Ambedkar said? I wanted to present for your consideration. In the Constituent Assembly, Dr. Ambedkar stated thus, there can be no difference of opinion that our judiciary must be independent of the executive and competent in itself. There can be no difference of opinion that our judiciary must be independent of executive and competent in itself. This statement is very, very relevant. This statement was made by Ambedkar to keep this institution as independent. You should not allow the executive, because it itself is competent to handle the judiciary. The moment you allow the executive to function, lost. This is what exactly everybody studied and started. The sitting judge of Supreme Court, V.Gopal, has made a statement. You must have read in the live law. In the paper also, you must have read it. I did not bring that paper. That is in the context of Madhya Pradesh High Court. A constitutional functionary judge, Sridharan, he rendered a judgment, suo motu case, in relation to a cabinet minister. In connection with that, the defense personnel lady, Qureshi, he was very critical. He took suo motu. Case must be registered against him. Direction was given to the jurisdictional police, register case against him. That was matter taken up to Supreme Court. Supreme Court, last week, direction was given to the government to register a case. There must be a sanction of the government under the Criminal Procedure Code. At that time, this BNSS was not public proposed. That time, suo motu case, Criminal Procedure Code was applicable. They were keeping pending that application. Of course, now BNSS, the timeline is fixed now. 45 days is the date. Direction is given by the first court today. Please give sanction within 15 days or 30 days, something like that, they have said. What Guyan has said in Pune endowment lecture, Sridharan was the presiding judge of the bench, directed to register a case against a cabinet minister. A request came from the political executive. In the collegium on 14th, please mark this date, 14th October 2025. In the collegium proceedings, recorded, Sridharan, the constitutional judge at the Madhya Pradesh High Court, shall be transferred from that court to the Chhattisgarh High Court. He was in the collegium, the committee. When they found that again he will be a collegium member in Chhattisgarh, again there was a pressure. He must be transferred from that place. You have proposed to transfer him to Chhattisgarh. Transfer him to the Allahabad High Court. He will not have the right of becoming a collegium committee member. In that context is said, what is reflected in the collegium proceedings of Supreme Court is marked this. That's why I said it is lost its independence. It is weak. It is independence is lost. Harilal Kania, what he said should not do is being done. Is V.Gopal's statement. He said, the executive, you have mentioned in the proceedings, the recommendation made by the collegium to the President of India to transfer him From Madhya Pradesh to Chhattisgarh, Chhattisgarh, again they have transferred into the Allahabad court. The credibility of the collegium is lost. Follow? You follow what I said? So this is what is happening. This is what is happening, what Kanya said, Yeralal Kanya said, the first Chief Justice. This is what Ambedkar has said should not happen. Is happening. That's why I said, please watch, act to protect this institution. Otherwise there will be no rule of law, there will be no democracy, no constitution. Constitution will be mutilated. That is why your role not confined to the courts. Please come to the states and tell that this is not correct. Second thing what he said was protect fundamental rights, harmonize them with the directive principles, secure political, economic and social justice. These are all the basic structure of the Constitution of India. This is what is said in Keshavananda Bharati. What do you mean by political rights, fundamental rights? Part 3, from Article 12 onwards, deals with the fundamental rights. Fundamental rights are not just like that given. Fundamental rights are human rights. Fundamental rights are natural rights. If the Constitution is not there, right to treat a person equally is a natural right. Why do you discriminate? Why do you discriminate between a sister and a brother? Why do you discriminate between religion, one Hindu religion and the Islam religion man? Why do you discriminate a poor man with a rich man? Why do you discriminate an elderly person with that of a man wearing the suit? Why do you discriminate between an agricultural laborer and a landlord? This is what the fundamental rights envisages Article 14. What 14 says? Article 14 says equality, equal opportunity, equal protection of laws. Equal protection of laws is to everybody, irrespective of the religion, irrespective of the caste, subcaste, region, etc., etc. No barrier. So that is fundamental right. That's what Ambedkar said. Protect fundamental rights. That's what has been said in Puttaswamy's case. That's what has been undone in ADM Jabalpur case. That was weak during emergency 1976. Whenever emergency, judges will fear. They don't function in accordance with the Constitution. You take the oath under the Constitution. What is the importance of the Constitution? Oath of Constitution. Without fear, favor, courageously, I render justice. During emergency, you are afraid of the executives. You, having taken the oath, can you do that? That has been undone in Puttaswamy's case. There again, revived the independence of judiciary. So independence is fluctuating, sir. It is fluctuating. Depends upon the regime. Emergency regime, declared emergency. Undeclared emergency, again. Think. This is what Ambedkar said. Harmonize them with the directive principles. But Jawaharlal Nehru in the provisional parliament, he made a statement. What he made a statement? He made a statement. I have to do justice, social justice. What social justice? Landlord, absentee landlord. Tillers will be there. Land to the tiller is the concept of social justice. Pandit Jawaharlal said, you have given Article 14, you have given Article 39A, Directive Principal State Policy. You have given in the preamble social justice, justice, social, economic, etc. if you say that justice to the tiller, I cannot give it in the present the structure of the Constitution, Article 31. Right to own the fundamental private property is a fundamental right guaranteed in 19(1)(g), the 19(1)(f). In the first provisional constitution of the Parliament, Pandit Jawaharlal Nehru, he made a statement. I am not for the capitalist. I am not for the tenants. I wanted to govern the people under the constitutional scheme. I have to treat everybody equally. Land to the tiller I have to give. Unless you amend the constitutional provision Article 31, I cannot render that. I cannot enact the law of land reforms. Abolish the landlordism. So 31 right to, fundamental right to own the property and acquisition, etc., etc. That amendment, first constitutional amendment to the 31 and also Article 15 to empower the woman. The 15.4, what it says is backward class of people in Chappagam Dorai Raju's case. There is also 1951 Supreme Court, Tamil Nadu. Backward class people, reservation in education institutions. Supreme Court has upheld it, struck down the circular. The Supreme Court did not keep quiet, and the Parliament did not keep quiet. They said they amended Article 15. So Article 31 was amended, Article 15.4 was amended. This statement of Pandit Jawaharlal Nehru made in the Parliament is the text of the judgment in case 1992 or 1992 Woman Rao's case. Woman Rao is from Andhra Pradesh. Constitutional bench. Beautiful statement is recorded. So speech of Pandit Jawaharlal Nehru. He said, unless I amend the constitution, it is not possible for me. So amend it. So therefore, you synchronize the fundamental right to achieve the directive principle of state policy. Article 38. Article 38 says, social order. Social order is again constitutional amendment in the year 1976. States shall strive hard to bring social order. What do you mean by that? State means who? Is judiciary excluded? No. Article 12 speaks of state means the Parliament, the Union of India, state government, instrument of the state, public sector undertaking, even the public discharge of duties is also as part of the state. In Jammu Kashmir case, education institution, ONGC, APSRTC, Cooperative Federation, these are all part of the state. So what it says is that the directive principles, equal opportunity, equal protection of laws. Equal opportunity means education. Equal opportunity means giving land. Equal opportunity means right to own a house. Equal opportunity is right to education. Equal opportunity is right to free health. That is what is contemplated. The land is a material resource. Water, river is a material resource. Forest is a material resource. Mineral health is a material resource. So these are all material resources for the common good. That is what is contemplated in the Constitution. So that should be the interpretation. That should be given effect to the interpretation of the constitutional concept. That's why Ambedkar said it must be secure, the armory and the directive principles. I can go on giving Article 39A, the material resource, Raghunath Reddy, 1976, this private contract carriage acquisition, nationalization. The private owners went to the Supreme Court. It was upheld. They went to Supreme Court. The acquisition was upheld by the Constitutional Bench, three-judge bench of the Karnataka High Court. It went to the Supreme Court. Justice Krishna, what is material resource is been interpreted. A workshop is also a material resource. A contract versus owner owning a workshop is a material resource. Nationalization of the roots, abolition of contract carriage. 88 Act in a different way it has come. That is a different matter. These are all very clever people. If once you render the judgment, annul the judgment, take away, without taking away effect of the judgment, you give a birth to in a different shape. Because we are rendering judgments. What happened? Justice Joseph in the Constitutional Bench, he said, election of an election commissioner, Chief Justice also must be a part of the selection committee. What did they do? They annulled the judgment. What are you doing? His independence of the judiciary said, Chief Justice must be a part of the election committee. Selection. You omitted him, bill is passed, annulled the judgment. So, the independence of selection, independence of the election commission, it is answered, you have to answer that. I am only presenting the facts. So now, the another aspect is secure political, economic and social justice. So without economic justice, can you expect a social justice? Without money, can we expect a scheduled caste and scheduled tribe and a backward class, rural village, peasant son or daughter coming to a law college and studying, becoming a lawyer and opening an office, opening a library, getting cases, without economic justice? Can you do that? Can you empower? Can you get justice? That's what Ambedkar has said. Secure, that's what preamble also says. That's what preamble says. Justice, social, economic and political. In that context, I want to deviate and say, this principle of justice, the concept is borrowed from 1948 Human Rights Declaration Act 1948. 50% of the women of the population of 143 crores. I asked the question to sister, how many lady lawyers are there? 87 lady lawyers are there. That's a good number. Earlier not even one. There was no encouragement from, no, if you become a lawyer, it's very difficult to get your partner and you will argue. You will not have, you please confine the household work you do. All this, that is not the trend today. Today 33%, I did not see any lady lawyer here, lady judge here. In my, when I was the Chief Justice, on merit, I am telling you not 33%, on merit large number of ladies are the judges there in Orissa. You are overtaking, but not in the High Court and Supreme Court. That is because we dominate, the male-dominated society. We may like say, sister, my cousin, oh, my mother, we'll say. But when the question of giving power, if you give empowerment, they will question us. So this mindset is there in every religion, every caste. This is because male-dominated society. So therefore, in that context, Ambedkar said, economic, political and social justice means political, economic and social justice. This 1948, women are given cultural rights, economic rights, education rights, political rights. Why? Why reservation to the woman Gram Panchayat chairperson? Why in a cooperative society woman reservation? Why reservation to the judges 33% in the district judiciary, not to the High Court and Supreme Court? That is because Why in the family court we prefer only the woman must be the, she will understand what is rape, what is sexual abuse. But I'm very sorry, my sister. Our sisters are not doing well in the family court also. They don't understand. When you give the power, you must exercise that power. It's a miserable fellow. 10 years, 15 years, 20 years, the matrimonial cases. When you are given, you come out from this thinking that you are, I am not saying that you must be prejudiced. Every rape case you are accused must be convicted. No. You better understand the feeling of a woman, sexual abuse in a workplace. You better understand, give them justice. Not going out of way on merits of the case, appreciation, section 3 of the Evidence Act. That's what is required. So therefore, I deviated. The independence of judiciary, you must be the part of 50%. Political justice also. You are silently watching and smiling. You know, clap at least from your side. Yeah, I'm in favor, your favor. So, at the point. Now, the early constitutional foundation 1950 to 60, from the inception, the Supreme Court was institutionally insulated through fixed tenure. 2. Removal only by impeachment. You are seeing the latest case of impeachment. You are watching? You are watching? Supreme Court very recently said deputy chairman also, the chairman Indian. And you must have read in the Hindu newspaper, P.D.T. Acharya said there is a lacuna in the Uttar Pradesh judge. The 50%, more than 50% is given to initiate impeachment for having made a statement in a conference of lawyers. More than 1.5 years is over. Nothing is happening. Nothing is happening to that memorandum. It's a statutory function. After giving the memorandum, nothing is happening. So, the impeachment, see, once you become a judge, impeachment cases are very, very minimal. This Verma is from Uttar Pradesh. The case is before the committee. I don't want to make any comment. But certain debate and discussion, Kapil Sibal will say, eminent criminal lawyers have said, they have said so many things about that. But he has raised a valid point. There was a memorandum given by another political party. Memorandum was given by NDA in the Parliament and the Rajya Sabha. That is the reason for receiving from the Congress and other, India constituents. Receiving itself is the reason he became illness, Vice President. Vice President became illness and he resigned. So therefore, the impeachment today is a Herculean task. There are so many things which are going on in this country. I don't want to go into that aspect. And financial security. The judicial review on Article 32 and 226. Financial security, see today, the computer engineer, of course in the multinational companies, the decision of the financial decision, salary completely reduced now, that's different. But you are seeing in the social media and the YouTubes, one person earning 12 lakhs per month. This is from Andhra Pradesh. And if he is earning 12 lakhs, who will become a citizen junior? Of course, there are a number of people coming and telling me, please put a word that I must get elected. I don't have any practice, I will become a judge. This is judicial. This has started even the constitutional courts. Sir, please put a word to the collegium members. I have got I want to become a High Court judge and the Supreme Court judge. Supreme Court judges also there is a recommendation in the collegium members. The collegium members are primary place. Other judges will not have the primary place. So this kind of the dilemma because financial security is not there. The financial security means I am not saying, yes, you must be happy what you have got. The district judge today, he will be getting 2 lakhs. Am I correct? Only 30 lakhs, 30,000 is more to the High Court judge. But you have got a free quarters. You have got orderly. You have got newspapers. You have got the respect wherever you go. Of course, it all depends upon they willingly give or not give, that's a different factor. But what is happening, if all put together, how much you are getting? You will be getting not less than. Economics must apply. House you must give 50,000. Orderly you must give 20,000, 25,000. Orderly means that's dignity not there. The 20,000 who will come and work, sir? So 20,000. Newspaper 10,000. Medical reimbursement, average you will get 50,000. You will get more than nearly about 3.5 lakhs. How many people will get 3.5 lakhs? A road tar fellow in the summer, how much you will get? Per day, he will not get more than 600 to 1,000. Of course, minimum wage is fixed. So 1,000 per day is 30,000 or 35,000. For a judge, yes, intellectual discharge of function. You are educated, you are double graduate, practiced, become a judge. Look at the person, disparity and equality concept is there. There the governance has failed. These are all the aspects must be taken into consideration. Though it is a separation of judicial, separation of power, you must take note of this and render justice. So now this financial security is there. It all depends upon your satisfaction. You have to grab the whole world, there's no end. That's what Buddha says. అత్యాస చాలా ఉంటే అది మితి లేదు. మీకు వచ్చే దాంట్లోనే మనకి సరిగా ఉంది చాలు అనుకుంటే అంతే చాలు. ಒಂದು ಲೇಡಿ ಗೃಹಸ್ಥಳು ಮಂಗಲ ಸೈನ್ ಹಾಕ್ಕೊಂಡ್ರೆ ನನಗೆ ಅದರ ಜೊತೆಗೆ ಇನ್ನೊಂದು 2, 3, 4 ಪಾರ್ಟಿಗಳಿಗೆ ಹೋಗ್ತಕ್ಕಂಥ ಆಭರಣಗಳು ಬೇಕು ಅಂತ ಅದು ತಂದು కొట్ట అది తెచ్చినాక ఇది గోల్డ్ ఇది నాకు డైమండ్ కావాలి సెట్ అని చెప్పాను. సో ఈ ఆశకి ఎక్కడ మితి ఉంది? సో ఫైనాన్షియల్ సెక్యూరిటీ ఈజ్ వన్ ఆఫ్ ది ఇంపార్టెంట్ ఆస్పెక్ట్ అంతా ಇಲ್ಲಿ early constitutional position and judicial review under article 32 and 226 32 itself is a fundamental right. You are seeing how Supreme Court reacts, like our people telling anticipatory bail. In some cases High Court, so directly they go concurrent jurisdiction. In some courts they will say go to the district court. District court in charge judge, concurrent charge is not there. He will be languishing it. I mean, he will be afraid. Though Supreme Court in 1980 Supreme Court Constitution Chandrachud, Bhagavati J has said what are the cardinal principles to grant anticipatory bail. No, but cardinal principles he will come within the non-cognizable offence. Okay, and there our judges just like that. I am sorry to make this observation. I never did it as a judge. The liberty of a person is most important. Your independence will be tested. Your perception is influencing you or not. Yes, you may be a rapist, you may be a murderer, you may be a dacoit, you may be anything else, but you are a judge. He is coming before you, seeking for anticipatory bail. I am not saying grant bail to the rapist. No, should not. Murder, no. Dacoit, no. But there are some cases where bail as a matter of right, even non-cognizable offence, even in a murder case, if the overt action charges and allegations are not there in the complaint, in the FIR, is a case for grant of bail. Oh, sorry state of affair or public prosecutors, what they are doing. You are part of a court judiciary, sir. You are a court officer. Filing objection statement, go and pester him and for extraneous considerations you file statement of objection. What kind of this the public prosecutor? What do you mean by public prosecutor? Public prosecutor means you are impartial public prosecutor. You must guide the court, assist the court to render justice. You cannot be a vindictive prosecutor. A prosecutor is a prosecution on behalf of the state, make available all the material to see that if a real accused person committed offence, convict him to get him conviction. There's nothing wrong. Filing statement of objection, anticipatory bail and a regular bail, how many dates of hearing? Please, for heaven's sake, more than a date, judges should not give objections. If they don't give, make a record in the order sheet that this prosecutor is not availing opportunity given. Therefore, I hear the accused counsel. Pass odds and dates, whether the objection statement is there or not. If objection statement is not there, it is not a case for grant of bail, don't grant. If it is a case for grant of bail, grant bail. Because the paramount consideration of liberty of a person are guaranteed in Article 19, and your action of granting or not granting, he will be tested under Article 14. The arbitrariness, reasonableness is the part of Article 14, is the fourth dimension of Article 14. So therefore, the judicial review, Article 32, violation of the fundamental right, yes, both Supreme Court as well as the High Court. In the High Court jurisdiction is concerned, 226, violation of the fundamental rights, violation of the statutory rights, also the forum jurisdiction of the High Court. So these jurisdictions must be exercised. Not only confined to the jurisdiction of the constitutional courts, the jurisdiction of the trial courts, according to me, they are the foundational courts. They are rendering justice to the common man who is in the lowest web, the last person in the queue. They are giving justice. They are most important. District judiciary is most important, is my understanding. Please avail. Please exercise your power, notwithstanding what the constitutional foundations 32 and 226. I was telling you about Gopalan's case, 1950 Supreme Court, Shankar Prasad case, 1951, while upholding the Parliament's amending power. Court asserted the constitutional interpretation remains a judicial function. Golkanath case, Court held that fundamental rights are beyond the Parliament's amending power, demonstrating willingness to conduct a powerful legislature. The Keshavananda Bharti I told you, the 13-judge bench, basic structure story, structure principle, which includes rule of law, is most important. Separation of powers, secularism. This is at stake today in India. I am very happy, not that I don't say minority. Some friends from the other religion also here. For that I take note of it. What is secularism? Some people will say it is what called pseudo-intellectuals. These people will say, they are disrespecting the phrase coined and incorporated in the by way of a constitutional amendment 1976. Secularism, he has that in Keshavananda Bharti, secularism concept was very much there. They propounded the theory and the law laid out in Keshavananda Bharti. They have reiterated by amending it, that's all. Socialist word also by way of an amendment, that's all. Otherwise, the structure and the constitutional scheme, preamble, part 3, 25 to 30, the secularism is very much there. We have to remember Swami Vivekananda. We have to remember Ambedkar Article 40. So therefore, this rule of law, the separation of power and secularism is important. This must be protected at any cost. Hate speeches, law is enacted, they get paid, again they repeat the hate speeches, insecurity for some religion people. We are seeing it. Assault is being made. Transportation under the guise that they are carrying something else. Attack is there. So secularism at stake today. What the secularism was defended by Vivekananda before the constitution, before Keshwaranda Bharati's case. Now, this secularism is again in Bomai's case, they have reiterated. Now, collapse and constitutional redemption is emergency. During emergency 75 to 77, judiciary in the darkest hour. Okay, the judges are damn afraid. Judges are today also afraid. I will be transferred from Andhra Pradesh to Chennai, Chennai to Allahabad, Ahmedabad, Madhya Pradesh to Chhattisgarh. This insecurity feeling among the judges, they may not say I am very fearless. They are fear. They have got the fear today. In the emergency darkest period, ADM Jabalpur case, they have said preventive detention, fundamental rights article 1914 is not curtailed, but they said if you are doing emergency arrested on visa, defense of Indian regulation, then DIR, they said you have no fundamental right. Right of freedom of liberty was curtailed, that's what they said. In ADM Jabalpur versus Shivkant Shukla's case, the majority held that even right to life could be suspended. What kind of judgment is there? Kanna, he is only the hero. 4 judges, majority view is different. As fundamental rights is suspended during emergency. Can it be done? Even a convictee, fundamental rights are not. That is the evolution of law today. That is what contemplated under the Constitution. Merely because he is a convictee undergoing sentence in the jail, can we say is fundamental right? What kind of judges and the jails today? Have anybody as a CJ? If you visit, first you must go to the urinals there. What kind of stinking smell they can leave? What kind of single cell they live? They are not human beings. They are not citizens of the country. Are they not provided Article Part 3 of the Constitution? Fundamental right. And yesterday when circular is issued by the DG of prisons telling only 2 pairs under trial, I am telling, under trial only 2 pairs of garments. Underwear, 2 pairs, wearing 2 pairs, and you shall not, of course, you can say from home you cannot get food. Okay, who give good food? Jail manual. Jail manuals must be revised, sir. A diabetic patient, if you give the carbohydrate food, he will suffer. Are you entitled to keep him suffering? Is the question. So, what we are doing? Why judiciary has failed? Why CJM is failed? Why the Chief Justice is not going around the courts? As executive chairperson, I used to go and conduct programs. We must give reformatory theory, we have to reform them. Once a convictee may not continue to lifetime a convictee. He is a human being. So that is the independence of the judiciary. Independence thinking is required for the judiciary. Not confined only case come before bail or jail, only specific performance case, injunction suit, rate of maintenance. These are not only the cases, sir. Cases outside the court, jail, your jurisdiction. Why the people are languishing without trial? You examine. No trial symptom at all. More than 5 years preventive detention in the court. Don't grant bail. Delay is the cardinal principle. They are all laid down in the Supreme Court in number of cases. So therefore, this kind of the draconian law to which judgment, the constitutional functionaries in the Supreme Court are the judges who have rendered the judgment that has been annulled. This judgment afterwards, 3 judges of the Supreme Court, supersession of the seniority. A. N. Ray was the unanimous judge among 3. The Grover, Shellett, K. Segre. All these 3 people resigned, protest. That you have to salute them. That is because they protested independence of judiciary at stake. Executives are overreaching. They wanted committed judiciary. You will not be there. You will come out. They are the heroes of the Indian judiciary. So that is what is happened in the ADM Jabalpur case. HR cannot dissent preserve the moral soul of the Constitution. What may come? I may lose my Chief Justice here, but I will uphold the constitutional scheme, the concept and the philosophy of preventive detention or detention during emergency. You shall not suspend your fundamental rights. The justice does not matter. The post-emergency self-correction, Maneka Gandhi's case, I told you already. The moment proved a critical truth. Judicial independence also means courage to admit and correct constitutional failure. Introspection is required. Is it this task is going on? Is the $1 million question. Anybody thinking on those terms? I wrote this judgment. What judgment? The judgment of Delhi High Court. A rapist Unnao, conviction, life imprisonment. Division bench in a matter where on an application you suspend the conviction and the sentence, grant the bail, a life imprisonment, with condition, the victim right. What is the victim right? How can she live? The father died, lawyer met with an accident, serious accident, powerful the MLA, ex-MLA. Huh? Is this thing, can a constitutional court of a division bench can grant this kind of order? What kind of your oath of office? What is the security for the victim, that lady? Rape, in rape case, in a democratic republic India under the constitution, under the nose of the Supreme Court, last day of the vacation, Supreme Court was not functioning, and she went before the parliament. She was not allowed to sit there now. She went before the opposition party. Lawyers, the freelance lawyers filed the appeal. CBI did not file the appeal first. After knowing that private persons are intervening, criticism will be there, women will be discussed, all these things. CBI people, CBI lawyer was changed before the Delhi High Court. These are the things which keep in mind in the court. What is happening, melodrama in the court, the judges must watch and render judgment. The Unnao case, very, very difficult. So of course, the Chief Justice, during the Christmas holidays, he took up himself, stayed at order. What happened? I forgot to mention. In Uttar Pradesh, CJM, in respect of that masjid, a survey to be conducted. police officer has encountered, opened the firing and died. That CJM is a courageous judge of Uttar Pradesh, some place, in some district. Against him, transfer order immediately from that place to other place. Is it the independent judiciary? Can we call that it is the independent judiciary? A judge who is a fearless judge, a courageous judge, directed the FIR to be filed against the police officer, the circle officer, for having taken the law into his own hands, firing. Is it the independent judiciary? Shall we call this as the independent judiciary? The Chief Justice or administrative judge transferring him from that place to another place? Transferring a constitutional functionary from Madhya Pradesh High Court to the Allahabad High Court? What kind of independent judiciary? The judge, we are expected to function courageously, fearlessly under the oath of office, rule of law. What is happening? What is happening? That's why I said, yes, independence. Yes, no, it is not independence because of these, the classic cases. Evolution of judicial appointment of India, 14th Law Commission report, CJ appointment and seniority convention, that is the Law Commission suggested tenure of 5 to 7 years, that is not taking place. Transfers under Article 222 of the High Court judges existed especially during politically charged periods. You have seen 1990, 124 judges were transferred. You have seen recent days from Telangana, from Amravati High Court, from Madras High Court, from Delhi High Court, transferring wholesale to another High Court. What kind of things? Why did you not see the antecedents of these persons at the time of the division? I am only mentioning Indira Gandhi era and the committed judges. Same thing will apply now also. He is not free from this era. He is not free from this era. Committed judges is not like under the Constitution, sir. Committed judges means not to your policy. Yes, your policy is to give effect to the constitutional mandate and the concept. I agree. You are the master. Sovereignty is given. You have been asked to function yourself effectively to give the social justice concept, empowerment of women, reservation to scheduled caste, scheduled tribe, protection to the other religion people. I don't call minority. No, all religions are equal. Give it their citizens. Why are you creating fear psychosis among themselves? No, don't do that. So all these things are very much required. Committed judges concept, the coining of the word at that point of time. I want to have only a chief justice or a judges who listen to me. My dictates means, is it a judiciary? Is it independent judiciary? No. That should not happen. In 1973, a seniority convention was broken. This is what I said, A and Ray. Over 3 senior judges. Later, M.H. Beg was appointed, Justice Khanna decided, who had courageously dissented. These actions deeply shocked judicial independence. These are the events which will shock the conscience of the people. During emergency, judges were transferred without consent. Sankalp Chand Seth's case, Supreme Court held that consultation with the Chief Justice must be real and meaningful. Consultation means just like that, like going to a doctor, consulting him, this is my ailment. No. The active participation of a judge, Chief Justice, is the consultation. Not asking, sending paper, I have consulted you. No, that is not consultation. That has gone. That has gone. Now, first judge case, 81 S.P. Gupta, held consultation is not concurrence. It is effective consultation, giving executive dominance, widely criticized. Second judge's case, 93, recovered, reversed the S.P. Gupta's case, 81 Constitutional Bench, created the collegium system, giving judicial primacy. Third judge case, 98 expanded collegium to 5 judges. NJSC and the 4th judge case 2015 struck down as violating the basic structure. That law was struck down. There is a comment, no, judges appointing judges. Who else can do that? Can you give it to the politician today? What will happen? FIR registering a FIR MLA, the nod is required. Is it, if FIR to be registered against one political party member, the nod of MLA is required, appointment of a judge to listen, to dictate terms, to follow your policies, that should happen. If that happens, can it be independent judiciary? Can they render judgment? Can they render justice to the people? That means only political party members who are at the point of time give judgment, the decision. How is it a justice? Is it the dharma of justice? Dharma is the propounded theory on which the constitution is propounded. Can we call this as equity, equality, liberty, freedom of expression? Without freedom of expression and criticism, can you allow anybody to allow the democracy to function effectively? These are all the various aspects in this NJSC case. Post NJSC reality, despite formal doctrine, executive delays reflect functional erosion of privacy, creating a fragile, so on and so forth. There are so many other aspects. I have already taken more than 2 hours, I think. I better to stop it here. Landmark judicial independence, Keshavananda, Minerva Mills case. This Minerva Mills case, part of the second amendment, judicial review gave direct principles of absolute primacy. It held that the limited amending power and judicial review. Chandrakumar's case, service jurisprudence, 97 Supreme Court. Decisions of tribunals were made subject to scrutiny at the high courts. Prevented the executive from bypassing constitutional courts through parallel, as I have already told. Appointments and institutional autonomy, first judge case, second judge case, third judge case, NJSC case. Next, federalism, secularism and executive control. You are now seeing whether federalism, federal structure, we the people of India. The Union of India is not the controlling, should not be allowed to control each state, sir. But what is happening? Federalism structure and fabric is lost now. Who has to say that? Only the judiciary can tell that. Is it doing? Not doing. Yes, partly doing. It is 9% interest. Indirect tax. Tax, not interest, tax. If you eat idli, 9% to the state, 9% to the central government. If you purchase a provisional store, you go and purchase anything, 9%. All 143 crore people, even an agricultural laborer is paying indirect tax. That amount, state money should be given to the state. You are not giving. Only 1 rupee collected, you are giving 40 paisa, 60 paisa you are retaining it. Is it a autonomy? Is it a federal structure? Or interfering with the state functioning? The legislative functioning? Is a federalism? That is at stake. That's what V.Gopal has said. Delhi Judicial Service Association case, Gujarat. If the court condemned in Supreme Court and humiliation of a judicial officer by police officials. Do you know what happened? When I was the Chief Justice, the World Cup match was going on. I came to Bangalore. I was not in Cuttack, the seat of High Court. I travelled back in the morning. I landed in the airport. My private secretary told me, sir, all lawyers in Western Orissa are on strike. Why? Yesterday night, judicial officer was going in a car after watching the World Cup cricket match. Police officer took him to the police station. He disclosed the identity, I am a magistrate. He did not listen to him. He came with the police station. Then, I told, before I reached to my chambers, I wanted number 2 and 3 person judges in my chamber. Call the Bar Council chairman. Call the president of the Bar Association. Call the advocate general. They were waiting for me. I went there. I listened to everybody. I asked my registrar general to come to my chamber. I told the advocate general, Mr. Advocate General, the SP must be transferred immediately from that place. And case must be registered against that police officer who is responsible in manhandling my officer. Unless you do it, I will not allow. Tell your chief minister. This is the command I give. This is the command I give. Within 24 hours, SP was transferred. He is a very powerful man. I said, I don't care whoever he may be. He must be transferred. PAL case came before me. In Orissa, peculiar thing is, in one place something happens, all courts in Orissa, entire state, they will be boycotting the courts. I took up the PAL. I told all these court persons, association leaders, leave it to me, I will handle it, please resume the work. I handle like this, they resume the work. So here, in this Gujarat case, the judicial review required, this one, police officers. It enforced Article 50, protected judges from executive intimidation. The police intimidate our officers, then they function freely. The judicial officers were recognized as essential to constitutional governance. That's why rule of law, that's why lawyers should not go on strike. If you go on strike, judge cannot hear without your assistance to grant bail. People will suffer. Why do you go on strike? Bring it to the notice of the court. Court will take care of them and handle them befittingly. We are empowered to deal them properly. That we have done. Now, Maneka Gandhi, I told you, Kutuswamy case, I told you, Sreya Singhal versus so and so, struck down section 66A of the Information Technology Act for vagueness, chilling free speech. The social media, you are seeing, they will tell anything, everything, every media, they conduct the media trial, they direct assassination of film actors, actresses, everybody, even politicians, they think that they are whole and soul. So, it protected the democratic dissent and online expression. The legislative overreach was finally checked. The judgment reinforced free speech as a core. This one. In Navajit Singh Johar case 2018, court decriminalized consensual same-sex. Look at the evolution of law taking place. Relations by striking down section 377 of IPC. Whether you may like it, we don't like it. This is the law. This is because Article 14, etc. I got my own reservation, and there are scientific reasons. The people will tell same-sex. My law clerk was there. She was studying 5 years law. She was telling, sir, the change. Our time is not this. Our time is the girls and girls. They live together. Gent and gent live together. This is what is Supreme Court has said. And Anuradha Basin case, Union of India, held that internet shutdown. This is Jammu Kashmir case. Jammu, you know it. That shutdown, this Ramana has passed, Justice Ramana. Restrictions on movement are subject to proportionality. The executive orders must be reasoned, temporary, and reviewable. National security cannot override constitutional scrutiny. These reaffirm the limits on emergency powers. Challenges and constitutional responsibility. Independence does not mean absence of accountability. It means accountability. Judges are answerable and accountable. This is what is said by Supreme Court way back 1977. Whatever the judgment we pass on whims and fancies, don't get the impression that you are not answerable. You are all answerable. Therefore, with all caution, care, judgment must be rendered. Either for extraneous consideration or fear, interference of the executive, you render the judgment, you are answerable and accountable. The public cry is there. Today, the immunity of the judge keeping in view this Delhi recent days of Ray Unnao case, the stay of the conviction and sentence has been, now discussion is on in the public domain. So therefore keep this in mind. From Harilal Kanya Foundation, the independent judiciary through Constituent Assembly resisted executive dominance, protected individual liberty, corrected its own failures, preserved constitutional democracy. The Indian judiciary is independent, not because it is flawless, but because it has never surrendered its constitutional conscience at the relevant point of time, after certain period, after new economic policies, after the emergency, during emergency, after emergency, or no emergency, the undeclared emergency. All these things are happening. Please be careful. Take up the real cause. Don't confine to the courts. Come out from the houses. Protect the rule of law. Defend the rule of law. Protect the constitution. Defend the democracy. Defend the nation. The democracy is at stake. Please ventilate the grievances of the people. Give out your opinions. Bring out awareness among the people. Who is doing what, including the judiciary. Then the country will survive. The constitution will protect it. 143 people. The last man in the queue will have the credibility, will have the confidence in the institutions and in the good governance. More particularly, strong independent judiciary is the essential aspect of the constitutional framework. Thank you very much for giving me audience of having patience. I must tell one boy here, the researcher, he is my boy. He is in Pune. I will be troubling him to give all the points. I asked him to come here. He has got a great future. He is a very good researcher. Any point if you tell, I wanted young members, if you take his number, he will tell you how to search statement, how to do research work, how to present the case. He is the final year. He has, with my help, gone to the Supreme Court twice, assisted the sitting constitutional judge. Now, again, I am sending him to Madras. I am showing him to you. You must also get inspiration. You can do better, and you will have a great future in this institution. Thank you, Mr. Madanapalli. Mr. Having this one. Our Sekhar has come from Amaravati, having come to know that I am here. Hitendra, yes, I know. They are all my well-wishers. You are also my well-wisher, that's why you have got me here. I am very much happy, very happy. ಈ ಯಾಪ್ ಮಾಡಲು ಈ ಪಾತ ಬಿಲ್ಡಿಂಗ್ ಸೂಚನೆ ಸಾಲ సంతోషమైంది మీకందరూ సంతోషమైంది మీకందరికీ మంచిగా ఇన్స్టిట్యూషన్ని ప్రొటెక్ట్ చేయండి అని చెప్తూ నా మాటల్ని నేను సమాప్తి చేస్తున్నాను.
It's very great. Next question. honorable officer. Preparation for the is I request honorable officer to unveil this posters. One more. ನಮಸ್ಕಾರ ಸರ್, ತಾವು ಇಲ್ಲಿ ಬಂದಿರೋದು ನಮಗೆ ತುಂಬ ವಿಷಯ ಇದೆ. ನಾನು ಕನ್ನಡ ಫ್ಯಾನ್, ಕನ್ನಡ ಬರೆಸಿ, ಕನ್ನಡ ಕಲಿಸಿ, ಕನ್ನಡ ಮಾತಾಡಿ. Honored sir, it's a great pleasure to stand before you in this august function. Sir, I welcome you to this land where the Hon'ble movement has rejuvenated, to the place where J.P. Krishnamurti propagated the humanism. This is the place where Rabindranath Tagore has uttered अहरह तव आह्वान प्रसारित सुनित उद्धारवाणी हिंदू बौद्ध सिख जैन पारसिक मुसलमान किरस्तानी पूर्व पश्चिम आसे तव सिंहासन पासे प्रेम हार कैघाता जनगण ऐक्य विधायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे. Sir, it's a great honor to me to hear your very profound very punching presentation about the judiciary, the judicial function, the constitutional implication, and the constitutional powers. Sir, as a student of judiciary, I heard a few words that Indian Constitution is gun that has never fired. Indian Constitution has got mouth to bark, but no teeth to bite. I was under the impression with these sentences, but after hearing your voice, your repository, judicial fervor, your great study over the subject, the legal jurisprudence, I salute you, sir, from this platform. Your presentation is good. Your human touch is a very fine fabric. Sir, here is a gentleman with a great honor, with great presentation, humanism. Sir, I place you among the three names which I have uttered: Rabindranath Tagore, Dr. Represent, G.D. Krishnamurti Garu, and here is Gopal Gowda. He is also part of this sand, this mud. Sir, he also took his breath within this campus, within this Madanapalli province. Sir, with a few words, I will just say, in concurring with the honor, the lecture delivered by Honorable Officer, Sir, Dr. Nani Palkiwala, an eminent jurist and champion of civil liberties, regarded the Indian Constitution as a sacred document designed to fasten liberty, equality and dignity. Constitution's basic structure successfully advocates for limitations on legislative actions if civil liberties are affected. Keswanandi Bharati's case, Minerva Mill's case, Vaman Rao's case are best examples. The apex court rejected the attempt to limit its power to scrutinize constitutional amendments, ruling that the judicial review is essential, unamendable feature. Judicial review is an essential, unamendable feature, which is reiterated in the review petition filed in 2024 of preamble changes. The Honorable Supreme Court in vociferous voice upheld the judicial powers to question the legislation whenever civil liberties are afforded. It also questioned the unlimited amending power under Article 368 and the basic structure of preamble is upheld. Constitution has been reared for the immortality but may perish by folly or corruption or negligence of its protectors, that is the people. So people should awaken to protect the interest of the society and the nation. The only platform is judiciary. So I request the public who are being represented by the advocate community, please rise to the occasion. Please protect the values of the judiciary. Please protect the constitutional implication, constitutional aspects, so that the society will cherish it. By concluding my presentation, I strongly recommend profound judicial system to uphold the democratic values of the country. So far as the clear judicial function is concerned, it also needs reformation, and I recommend Indian judicial service so as to welcome cream of society and intellectuals into the system, so that the political elements automatically set right themselves instead of judicial checkup and checks and balances. Sir, once again, I am very, very immensely thrilled with the words, with the presentation and the punch that the officer, the Honorable Supreme Court Judge has presented for us. Augustus function. Sir, really virtually great. I am very, very happy to be a part of this function. Jai Hind.
Some of our advocates having some doubts, sir. They want to have some clarifications. If your lordship permits, I will hand over mic to those persons. Who will ask first?
Good morning, sir. I am very happy that you presented here to deliver a lecture on the topic of Indian judiciary independence under the Indian Constitution framework. Sir, first of all, I am very happy to hear you presented the way. I was about to ask some questions, sir, but I listened to your speech so that Your Lordship, my question is, does collegial system compromises the judicial independence in India? Does collegial system in India is compromising or not?
My speech is the answer. My speech is the answer.
Yes.
Collegial system is an alternative, effective, good system where through the consultation has been interpreted concurrence of a Chief Justice. Now today, have regard to the ongoing realities of the society. Right from 1950 to 2026, we have traveled a long journey. In between, there are so many things have been happening. I have with reference to the cases I said, which have come to the notice, which have been hidden. There are so many things. What we thought of a effective alternative collegial system in selecting the constitutional court functionaries or judges to the High Court and Supreme Court. The compromising taking place is the sign which we are experiencing in the court performance by the judges. This is evident from the performance, selection performance. So therefore, the ongoing one important thing which we have to keep in mind. Minerva Mills case, the Constitution bench judgment, 5 judges, interpreting Part 3 and Part 4 of the Constitution, both constitute human rights. They have clearly said that I made a statement. One important statement is there in the judgment. Please read, go home and take your library, go to the library, or take Google. The judges are this is the quotation I am telling you. Judges are the custodian angels. Judges also must listen this. Keep this in your heart and function. Judges are the custodian angels of the ongoing events. The Supreme Court has felt that they will understand what is going on in the society, take note of it and function. Now you are not the judge. You are a judge in the sense to judge the events that are taking place in the system, which you can come to know whether it is compromising or not compromising. The nature of persons who are identifying and selecting, and the relatives, the grandson, son, like a hereditary office, and leanings of the political party, they are the persons who have been identifying and selecting the constitutional judges. There are certain observations and comments are being made persons who are in the collegium and outside the collegium and the sitting judges. This is the collegium system, the object for which it has been established. We are not achieving the results. There must be some corrections take place to effectively make the collegium system go to select the High Court judges. That's my answer.
So you learned there is a nepotism.
Yes, definitely the nepotism is there. If it is not, how can you, grandfather, son, grandson, becoming the judges? Is it a hereditary office? One. And particular class, caste, to dominate, don't recognize the merit in the other side, other sections of people, other sections of the region, neglect a person in the society, they are in the darkness, not see the light of the day. Have you recognized them? Are you considering them? Why you are not doing it? Why are you not recognizing the women? There are a large number of thousands of people, women. Elevation to the High Court and Supreme Court. If not 50% population, 50% the population of the lawyers may not be there, they are women. At least some sizable number of people who have rendered. High Court judges, there are people, they are remaining good youngsters who are there, give them opportunity, different sections, different castes, different religion people, why are you dominating it?
So you learned if there is any way that we can control this.
Only this can be controlled only by the people and lawyers like you.
Thank you, Lord.
Any number of questions you can ask. I am here. I am not agreeing.
Your Lordship, very good morning to everyone. It's a great pleasure to me to present before me on this occasion of 76th Republic Day. And I'm going to put a question that what's your interpretation on trial in absentia? And this is not violating against the justice. I mean trial in absentia. Yeah.
Is bad. Of course, in the presence, there are judgments for your kind information. The same question sitting district judge asked me. There was a criminal murder trial. On merits, the accused, the case was splitted. Such a person absconded. They did not appear for the trial. The persons who appeared, they got acquitted. Public prosecutor, thereafter these people came, who the absconded accused. He made a statement, the earlier judgment holds good for that. But Supreme Court says, the accused who have absconded later appear after the judgment faced by persons who faced the trial. The case must be tried insofar as they are concerned. What evidence is given the accused who are before the court, suppose there was a conviction, it is acquitted. Can you give the conviction without hearing him? He may have a valid defense. He may plead. So, virtual technology has developed. I understand why you have put this question. Virtual hearing is permissible. Watching trial is not permissible according to me. We must be present before the court. In an open court with trial. Supreme Court, way back in 1968, Constitution then said, what is the open trial, open court trial? That is the right given to a party, a litigant and accused That is the right. He must be present. Judge must watch his demeanor. He must see how the judge is recording evidence, hearing what is the attitude. He must have the confidence in himself by facing the trial in the open court. So absence or virtual appearance is no trial.
Thank you for this valuable information. Respected all the dignitaries and former Chief Justice of India, good morning, Canada, and hearty welcome to
I
Madanapalli.
have to compliment this side, my sisters. So many people are there, they are not even 1%. This indicates that you are all competent enough to get the judges or appointed by ladies judges. I am very happy that you are putting questions. But here my young brothers, they are not putting questions. It is a good, happy development.
Thank you for this kind of encouragement, and we are always welcoming this kind of encouragement, and we are here for all these questions. Today we are putting forth it. And my question is, Your Honor, taking all the laws into consideration, what is the role and essence of uniform civil code? Taking note on equality, is that possible in India?
Article 44 envisages the common civil code. My dear sister, Article 44 must be read into Article 30 of the Constitution of India. Common civil code, a political document recognizes multi-religion system, multi-religion country, multi-caste country, multi-subcaste country. Each religion will have their own custom. Custom is the source of law. 1939, the Muslim Divorce Act. Indian divorce, so far Christians are concerned. Marriage and other aspects, the custom and rituals are protected under the Constitution. Can you impose all the customs by giving a goodbye to the customs and rituals which are practiced by one religion? Can you do that? Can within the one Hindu religion, tribal Hindus, scheduled caste as Hindus, scheduled tribe people are Hindus, in the caste there are too many subcastes in Vakaligas. Vasadevaru Vakaligas, Kottadevaru ఉండేవాళ్ళు. కొత్తదేవుడు ఎక్స్పెక్ట్ చేసి నువ్వు కామన్ సివిల్ కోడ్ రమ్మంటే నువ్వు వింటావా? జనాలు వింటారా? ఎవరన్నా చెప్తే వింటారా? అవుతుందా సాధ్యమా ఇది? ఇది ప్రాక్టికబులా? ప్రాక్టికబుల్గా ఉంటే రియాలిటీనా? ఇది సాధించేది సాధ్యమా అనేది ఆలోచించేసుకొని కామన్ సివిల్ కోడ్ కావాలని చెప్పి కూడా ఆలోచించేయాలి. అదే అర్థం చేసుకోవాలి. Yes, it is there, but that is a long journey for us. Marx మాట చెప్తాడు, Karl Marx, a propounder of a egalitarian system of society. నువ్వు ఈ యూట్యూబ్లో కార్ల్ మార్క్స్ది అది ఎవరో ఆయన ఉన్నాడు ఫేమస్, లైఫ్ హిస్టరీ అంతా చెప్తాడు. అది కొంచెం వినాలి. ఈ 9 గంటలు 10 గంటలు అయిన తర్వాత యూ గో టు ద బెడ్ అట్ 11 o'clock. 1 or 2 hours ఆల్ ఆఫ్ యూ మస్ట్ అదేమి టాక్ అదేమో చెప్తాడు కదా. అది తెలుగులో ఆయన బాగా చెప్తాడు. ఆయన పేరు కిషోర్. అదేమి ఈ పాత సినిమాలవి, ఈ సినిమాలో ఇంటి రామరెడ్డి పాతాడు బయలు పెట్టి చెప్పా వీళ్ళు ఇట్లండ్రి అంటే చెప్తారు. ఏంటది ఆయన కిషోర్ టాక్ ఏమో అంటుంది అదేంటి. ఆయన అమెరికాకి పోయి వచ్చేసినాడు, మన ఆంధ్ర ఆయన దీంట్లో వస్తాడు, యూట్యూబ్లో వస్తాడు ఆయన. ఆయన కార్ల్ మార్క్స్ ఏం చెప్తాడంటే, ఇట్స్ ఎ ప్రొపౌండెడ్ థియరీ ఇన్ ది 18th century. Karl Marx theory. It is universal theory. Universal accepted theory. Equality concept అప్పటికే ఉంది, అంతకు మొదలే ఉంది. 12th centuryలో బసవన్న రిఫార్మర్ అయిన. Karl Marx is not a reformer. Karl Marx is a reformist, revolutionary. Karl Marx theory was implemented by Lenin in Russia. 1917లో workers against the Tsar system he fought, and revolution took place. Proletarian dictator rule వచ్చింది అక్కడ పీపుల్స్ డెమోక్రసీ. ఆయన చెప్పాడు అక్కడ కార్ల్ మార్క్స్ ఏమనంటే స్టేట్ పవర్ విల్ విదర్ అవే. చూడండి, ఇప్పుడు స్టేట్ పవర్ అక్కడ ఫంక్షన్ చేస్తున్నారు కదా, ఈ అసోసియేషన్ స్టేట్ కాదు, బట్ మా జడ్జెస్ ఉన్నారు మా పార్టీలో. ఇక్కడ ఎంత జనం పోలీసు వాళ్ళకు ఉండాలి, ఎన్ని వెహికల్స్ నింపుతున్నారు అక్కడ. స్టేట్ పవర్ ఇస్ యూ డి నాట్ ఎక్సర్సైజ్ యువర్ పవర్. My state gave me the police escort. Supreme Court has sent you yesterday night to you. Most urgent. I don't know whether you spoke to the SP or not. Please take it to the notice of the SP. I am a state guest in every part of the country. Personal district judge, I don't want anything. I have got people like, number of people like you, my brothers and sisters are there. State power will wither away. పోలీసు వాళ్ళు, ఆఫీసర్లు ఎందుకు అక్కడ? స్టేట్ పవర్ అంటే అట్లుంటుంది. ఈతో స్టేట్ పవర్ జుడిషియరీకి వీక్ అయిపోయినారు మీరు. యూ మస్ట్ కమాండ్ దట్ సర్కిల్ ఇన్స్పెక్టర్ ఎస్పీ హియర్. యూ షుడ్ హావ్ టుమారో మార్నింగ్ యూ మస్ట్ డూ దట్ ఎక్సర్సైజ్. ఐ వుడ్ హావ్ బ్యాంగ్డ్ దెమ్ లైక్ ఎనీథింగ్. ఐ యామ్ టెల్లింగ్ యూ. స్టేట్ పవర్ మీకు విధానమే చెప్తుంది. అర్థమైందా? ఏమంటే క్వశ్చన్, ఏం క్వశ్చన్ అనేది? కామన్ సివిల్ కోడ్ అని కదా. స్టేట్ పవర్ ఉంది, పార్లమెంట్ కి లా ఎనాక్ట్ చేయొచ్చును. లా కమిషన్ యూనిఫార్మ్ సివిల్ కోడ్ చేయాలి. ఈ స్టేట్ లెజిస్లేటివ్ అసెంబ్లీ కాదు. కామన్ సివిల్ కోడ్ ఇది దేశానికి కావాలని అంబేద్కర్ అక్కడ చెప్పిండేది 44. 77 ఏళ్ళు అయింది కదా, ఎందుకు తేలేదు కామన్ సివిల్ కోడ్? సోషల్ జస్టిస్ అంతా కానూన్ తెచ్చినా కదా, సంవిధానికి అమెండ్మెంట్స్ అయినా కదా. వాళ్ళకి తెలుసును ఇది తెస్తే ప్రాబ్లం అవుతుంది, ఒప్పేది లేదు, ఫాలో చేసేది లేదు. లా ఏం చేస్తారు? లాని చేసేది ఫాలో చేసేదానికి, రూల్ ఆఫ్ లా మెయింటైన్ చేసేది. మేజర్ కమిటీ హిందూ వాళ్ళే చెప్తారు, అదే నేను ఫాలో చేసేది నా రిచువల్. కామన్ సివిల్ కోడ్లో కస్టమ్ రిచువల్స్ ఇవన్నీ ఏం కావాలి? ఆర్టికల్ 13 ఏం కావాలా? ఏం చెప్తుంది ఆర్టికల్ 13? చదువుతా నేను. ఆర్టికల్ 13 లాది తెలియకుండా ఏదేదో చెప్తా ఉంటారు నేను. గిమిక్, ఓట్ గిమిక్, ఇవన్నీ అవన్నీ మీరు చెప్పాలా? ఇవన్నీ ఓట్ గిమిక్, ఇవన్నీ ఇన్నది నేను చెప్పాలి. అర్థమైందా? నేను ఎప్పుడు చెప్తా ఉంటాను, గిమిక్ మాస్టర్ గిమిక్ పని ఏం జరగలేదు ఇక్కడ మన దేశంలో. అది కొంచెం తాత్కాలికం అంతే. అది చదువుతాను. ఆర్టికల్ 13 అంటే ఏమి? లా ఇంక్లూడ్స్ ఎనీ ఆర్డినెన్స్, ఆర్డర్, bylaw, rule, regulation, notification, custom or usage having in the territory of India the force of law. Custom is the force of law. నువ్వు యూనిఫామ్ సివిల్ కోడ్ తెస్తానని ఇంక చెప్పి నీకా వద్దయ్యా అంటే వింటావమ్మయ్యా నువ్వు కాంట్రాక్ట్ ఇక ఇస్లాంలో ఇట్ ఇస్ ఎ కాంట్రాక్ట్, హిందూలో ఇట్ ఇస్ సాక్రోసెంట్, ఇట్స్ ఇన్స్టిట్యూషన్. వాడు నీకు అంటావా ఇందులో అంటావమ్మా? నీకా చేసుకుంటాము, కాళ్ళు కట్టేదొద్దు, కాళ్ళకి ఇది వేసేదొద్దు, తండ్రి వచ్చి అక్కడ కన్యాదానం చేసేదొద్దు అని చెప్తే వింటావా నువ్వు? వాడు అప్ప అమ్మ వింటారా? అది వస్తుందా, అవుతుందా? ఇంకోటేమి, లా ఇన్ ఫోర్స్ includes laws passed or made by legislature or other competent authority in the territory of India before the commencement of this constitution or not previously repealed, not present, etc. etc. ఏదో ఆమెట law that will be made inconsistent with your violation of fundamental right, it is just to avoid laws inconsistent with or in derogation of the fundamental rights, equality, fundamental right, equal opportunity, fundamental right. 13 law custom is a fundamental right. 13 article law, fundamental right custom. Arthamainda? Freedom of expression, you can say I will not accept it, I will accept my custom. Can you take away that? Again, before the commencement of this constitution, insofar as they are inconsistent with the provisions of this part, shall to the extent of such inconsistency be void, శూన్యమది, ఆ లానే శూన్యమైపోతుంది. ఆర్టికల్ 13 లో అర్థమైందా? కమర్షియల్ కోడ్ కావాలా నీకు? కావాలా?
Thank you for giving this kind of clarity. And many people in India have this doubt actually. So I am representing.
Vote gimmick. వెనకాలకు వస్తూ ఉంటాయి ఏమంటే బొంబాయి చూపిస్తా, కలకత్తా చూపిస్తా, 4 గంటలు తీసుకొని. అదే ఇది బొంబాయి కాదు, జనాలు ఇక్కడ 143 కోట్లు, దాంట్లో 20 కోట్ల జనాలు ఒక అనుకుంటారు, ఇంకొక 3-4 కోట్లు ఇంకో అనుకుంటారు. అంతే ఈజీ కాదు. ఊరికే చెప్పేది, మాటలు చెప్పేది ఈజీ, నడుచుకునేది చాలా కష్టం.
Thank you, sir.
Is both on the judicial side and the legislative side.
Sir, I just came to know from Madan that you are the founder of SFI. It's a very glad statement, right? And your elaborate speech, you mentioned many aspects regarding the judicial function. Actually, I had many doubts to ask you, but viewers have raised many questions about it. Judicial functioning, especially regarding independence. What I would like to ask you is, you have already given so many examples regarding transfers and all these things. I had a fundamental question. As you said, there is separation of powers and judiciary administration of the judiciary itself, and financial freedom also it has because it is in the common, consolidated fund. So in such a case, why is the judiciary is still not independently acting? And what measures you suggest to reform the judiciary to act independently, especially the inaction by the judiciary is a serious concern nowadays. The proactiveness is very essential nowadays. And what measures you suggest? I request you to give. Thank you.
Wonderful, very relevant question which you have asked. It is not the seat of authority got all powers under the Constitution. Constitutional framework contemplates, envisages, oversee the functioning of the executive and legislature by the Indian judiciary. That to happen and implement, act upon that, your oath of office is very important. Merely taking oath of office is not sufficient. Such kind of personality must occupy that seat of office. You must have the courage and conviction. Like Richard Khanna, whatever it happens, I write judgment dissenting. That kind of chief justices and judges we require. Not only one chief justice. We require a strong, courageous, convicted, constitutional conviction is required for a judge, not only to the constitutional courts, to all the district judiciary judges. The CJM of Uttar Pradesh, having noticed suo motu, he directed to register a case against a person for ordering a filing and death had taken place. So he had the courage. We require people like that. A civil judge, senior civil judge, district judge, we want strong, not physically, mentally strong persons we require. I told you my example. I used to tell my Chief Justice in the Supreme Court, Justice Thakur, the present Chief Justice brother, when you are recommending the appointment of judges, executive keeping the files lying on the office, in the office of the Prime Minister PMO office, post those cases before me, I will handle them. I told you. Follow? I will handle them, I will see that all appointments will take place. That kind of strongness, not physically, mind strongness and courage and conviction, whatever may be the consequences, you may not become a governor. I don't want to become a governor after retirement. I am a former judge of the Supreme Court. My writ will run to the people. That kind of the self-interest must be given up. You must have satisfaction. You have travelled up to Supreme Court, you are there, you have rendered judgment, millions of the people are benefited. Wherever you go, say, sir, I am beneficiary of your judgment, they will say. So, it is not after becoming, I must become a commission, I must become a human rights chairman, I must become a national judicial. What nonsense, sir. Be with the people, do service. You have got house, you have got family, you have got car, you have got everything. That kind of people are there, independence of judiciary will automatically come. That kind of, the daughters and children, you must give birth to them in this country. People are there. Such kind of people must be selected. I hope I have given you answer.
So, one more question. A very good afternoon, Your Honor. I am really happy to be a very progressive, proactive and a legendary talk happening this under the esteemed Madanapalli Bar Association. Because nothing has stopped me sitting here, not a 3-month-old baby who's crying, neither some tooth repairs that needs to be done. Because legends don't die. The example of it is sitting in front of me. I'm just looking at you. Each and every word of you is inspiring like a fire. And it happened to be as if we want to get to the court or we want to get out of this area and we need to fight for justice and freedom. But let us coming to the point. In recent times, Your Honor, we see public criticism, personal attacks on Chief Justice of India and the judiciary on social media and public platforms. From a constitutional point of view, what long-term consequences can this have on judicial independence and public trust in judicial system?
Very pertinent ongoing comments which I have raised. A very, very serious subject. Very serious matter. Our people have got wisdom, lot of respect and confidence and respect in the judiciary. It is not to make comment, criticism. I am saying constructive criticism of a judgment is allowed. Destructive criticism is not allowed. Not to allow every Tom, Dick and Harry to criticize. That will affect the functioning of the judiciary. I told you with reference to 94 that Padmanabh Iyer case, Bhattacharya, royalty of a book, he has suffered, the Chief Justice in Bombay. He is from Calcutta, West Bengal. There is a passage from United States of American judgment. The judiciary is meant for the masses of the country. Rule of law, render justice, etc., etc. Now, we have become a laughing stock today. You write judgment ignoring the law precedent. That journalist, what is his name? Not Pranab, that Arnab Goswami. He was interviewing the Chief Justice, recently debuted the office. That Arundel case. Why did this Chief Justice go to his panel discussion? Number one. If he had gone, if he had put me the question, I would have bounced back on it, Goswami. Because I have got that courage and conviction, inner strength. He was asking a question. Why did you not follow the law precedent in this case? What was the mark of hurry for you to render the judgment? Law precedent is ignored. If law precedent is ignored either by Chief Justice or a judge, there is nothing wrong to expose such person. If a harmless person is criticized, that is wrong. So, accountability you must keep in mind. You are going to dimit your office, I write judgment, whatever matter I write. People will not tolerate. Journalists will not encourage. Journalists are the watchdogs. So, answer is self-criticism, constructive criticism, introspection of a judge is most important, not in your personal interest. In the interest of the credibility of the institution that is vanishing today. That's why we are required to protect that institution in selecting good, honest, integrity judges, Chief Justices. You should not feel whatever you like, you will pass the judgment. People will not accept, you will be a subject matter of criticism, you will be exposed. Not only he, his predecessor. Not only his predecessor. The only answer is, you have seen a good officer who will be transferred, who is in the executive, he will be felicitated, respected, give love and affection. Even the judges, who can judge? Judges will decide the case, but judges' reputation, integrity will be judged by the lawyers and the public. That is the answer.
Sir, Namaste, sir. I am immensely glad that we have touched the excellent recessive points that are to be discussed everywhere, sir. Especially the Unnao case, which has really affected the common man's feelings in a very bad manner. Another thing is that judiciary, after the judicial officers, after having attained superannuation, they prefer to go for nominated posts, and this is leading towards the misunderstanding in public with regard to quid pro quo or psycho-fantasy culture that may appear in our country with regard to the judiciary. And even though the 14th Law Commission has clearly mentioned that one is not supposed to occupy such posts immediately after superannuation, and yet it is going on, and even without following a cooling period. In this issue, what suggestions that you can make, sir? Please. Thank you, sir.
Mr. Jetli, the late law minister, was a senior designate lawyer who became a senior counsel within 10 years of his practice as a lawyer. He was a law minister. He was holding number of posts in the Vajpayee government and present the present cabinet, previous cabinet. He died. He has made a statement. There must be a cooling period for appointment of giving a appointment or giving a commission to the sitting judges. Now, the fault lies with the executive. There are a number of fora has been established. Human Rights Commission, Law Commission, the Finance government commission is there. This Loka Acta, Upaloka Acta, and the recent judgment that after 98, the judgment that Lokpa. Do you know the secret of Lokpal appointment? You wanted me to tell? I'll tell. I am fearless. I am telling you. The ED case constitutional validity was upheld. Not only upholding that, he has said so many things. He became a Lokpal. Okay? These post creation, you must have like civil judge, senior division, judicial division, senior division, district judge, high court judge. So you must independently have persons to fill up those posts. Why are you giving this? This is a strategy, very convenient strategy found out by these political executives to keep them under their control. Shameless. Shameless people will accept that. For me, I am telling you, I got in 3 states offer. I wrote the judgment in Singur, land acquisition, Tata. I was only the person who has struck down the acquisition. During the communist rule, they acquired. Mamata Banerjee in Rome, she said to my colleague, he has written a wonderful judgment striking down the acquisition. On my behalf, will you make a request? 5th is going to demit, 6th is going to demit his office, 6th October 2016. Before he laid down his office, his appointment order will be in his house as a Human Rights Commission chairman. One offer. Madhya Pradesh, the chief minister wanted to meet me to offer Loka Acta. Orissa file was kept. Loka Acta, I will offer Loka Acta. Kerala state government, chief minister, former chief justice of India, 2 advocate generals telephoned to me to take my concurrence. In my Karnataka state, I made a statement 4 months earlier. I am not going to accept any position after my retirement. They requested me to please change, sir. We wanted to appoint you as the Loka Acta. these offers, I refused. I am telling you. Refused. My court, my function are the people of this country. That's how I am before you today. I wanted to be a free man. I wanted to go to the people, listen to the people, their agony, their tales, their suffering. That is more powerful than all these commissions, Lokayukta, etc., etc. This is a strategy of these political executives to keep them in good books, to write judgments to the present, a political executive system, which is very bad. People must also fight. You are creating the position, please appoint persons independently, not the retired judges. They will get the retirement fee, arbitration, lakhs of rupees they will earn. What more else you have to earn? You have to grab. Why should you grab? Let everybody, the material resource, distribute among everybody.
ನೀವು ಇಲ್ಲಿ ಬಂದಾಗ ತುಂಬ ಆನಂದವು ತುಂಬ ಸಂತೋಷವಾಗಿದೆ. ಅಂದರೆ ನಾವು ಕೂಡ ಕರ್ನಾಟಕ ಫಾರೆಸ್ಟ್ ಕರ್ನಾಟಕ ಸರ್ తెలుగు చదువుకున్నంత తెలుగు. ఓకే, థ్యాంక్ యూ సార్. One of the senior member of PM Economic Advisor Council had made a statement during the national conference, that is Sanjeev Sanyal. He had made statement, the judiciary, Indian judiciary is the biggest hurdle to achieve the Viksit Bharat. If it is so, tell me sir, and if it is not so, why the Supreme Court did not take contempt proceedings against him?
అదే క్వశ్చన్ ఇదే. ఇప్పుడు ఏనుగు పోయేటప్పుడు కుక్కలు మరుగుతా ఉంటాయి బాబు, అర్థమైందా? ఏనుగు పోతానే ఉంటుంది, కుక్కలు మరుగుతానే ఉంటాయి. వాడు కూడా మాట్లాడని చెప్పేసి మనం రియాక్ట్ చేసి మనం కంటెంట్ చేస్తే జైల్లో పంపించున్నాం. వాడు ఒకనే కాదు బాబు, ప్రతి ఒక్కరు ఎవరెవడు బేజవాబ్దారిగా మాట్లాడతారు కదా. Every one such person must be kept in jail. Contempt jurisdiction. Magnanimity of the judiciary. నీ కోర్టులో ఒకనాటికి ఒక లాయర్ పైన, ఒక కక్షిగారి పైన నేను సీరియస్గా జడ్జి పని చేసి కంటెంప్ట్ ఆఫ్ కోర్ట్ యాక్ట్ 1971 ఇంక్లోజ్ చేస్తే సనత్ పోతుంది, వాడు జైల్లో ఉంటాడు, కక్షిగాడు అలా చేస్తారు. ఒక పెద్దతనం అంటే ఏమింటే ఏదో వాడు మాట్లాడేదానికంతా మనం సీరియస్గా తీసుకొని మనం జైలుకి పంపిస్తే మనకేమో చేయవస్తుంది బాబు. ఈ కంటెంప్ట్ జ్యూరిస్డిక్షన్ని బాగా స్పేర్గా ఉపయోగించాలి. అధికారం ఉందని ఎలాగంటే అలాగే ఉపయోగించి అందరినీ జైలుకి పంపించేది సిస్టమ్ కాదు. ఇలాగే మాట్లాడతారు కదా, ఆ మాట్లాడేది వాడికి సంధానము ఏమేనైతే తెలియదు, స్థానమానము న్యాయాంగంలో ఎంతుంది అని కూడా వానికి తెలియదు. కాబట్టి మరుగుతాడు వాడు, మరుగుకొని ఉండి ఇంకా అట్లా సీరియస్గా చేస్తే వాడి పైన జైలుకి పోతాడు. దానికి నువ్వేం తొందరపడద్దు, జనాలే ఉత్తరం ఇస్తాడు వాడికంతా.
One more question, sir. Under Article 200 and Article 201, they both assent due to the bills. They are time limits no mentioned here. Time limits they have done.
That amendment అయింది చూడి.
Sir.
Expeditiously.
Yes, expeditiously.
That is the reference for consideration before the reference court.
Yes, sir.
And also this April judgment of Tamil Nadu.
Yes, sir. So 142 కింద Supreme Court ఉన్నటువంటి powers, when a matter is pending before the Supreme Court, that Tamil Nadu case, it is limited, sir, or 100 to secure the ends of justice.
There is a judgment, is a binding precedent, sir.
Yes, sir.
They have raised the question. They have answered the question.
Yes, sir.
నీ వరి ఏమి నాకు తెలుసును. రెఫరెన్స్ కేసులో మా ఫార్మర్ చీఫ్ జస్టిస్ ఆన్సర్ చేసిపోయినాడు అని. That answer does not take away the effect of the judgment of Tamil Nadu. అర్థమైందా? ఇది రోగం వచ్చేసింది వీళ్ళకంతా. ఏం రోగం తెలుస్తున్నా? క్యాన్సర్ రోగం. అతనికి గవర్నర్గా పంపించినది మర్యాద స్థానంలో సరిగా పని చేయవయ్యాలి. ఆ పని నువ్వు నీ డిస్క్రిప్షన్లో పని చేయాలయ్యా. నేను అపాయింట్మెంట్ చేసినప్పుడు చేయాలి. వాడు సిస్టము హైకోర్టు జడ్జి కూడా ప్రైమ్ మినిస్టర్ పాస్ చేసి ప్రెసిడెంట్ ఆఫ్ ఇండియా ఇస్తారు. ప్రెసిడెంట్ ఆఫ్ ఇండియా కేసు మా ముందు వస్తే ప్రెసిడెంట్ పేపర్ రాస్తాం. మనం కేసు ఎగెన్స్ట్ ఉంటే దట్ ఈస్ ది డిఫరెన్స్ బిట్వీన్ జడ్జ్ అండ్ అన్ ఆర్డినరీ ఆఫీసర్. కాబట్టి గవర్నర్గా సకల మర్యాదల్లో గవర్నర్ వ్యాప్తిలో వాడు పనిచేస్తేనే జనాలు గౌరవిస్తారు, వాళ్ళకి పనిచేసేదానికి ఇస్తారు. అర్థమైందా? ఇది అసెట్ ఏమంటే డిరైవ్ చేసేదానికి ఇది అన్కాన్స్టిట్యూషనల్. ది సావర్నిటీ పవర్ గివెన్ బై ది పీపుల్ టు ఎలెక్ట్ దేర్ రిప్రజెంటేటివ్. వాడు ఎలక్ట్ చేసినప్పుడు కానూన్ చేస్తే, బిల్ చేస్తే, పాలసీ మన మేనిఫెస్టో ప్రకారము బిల్ పాస్ అయ్యింటే నీదేమి అధికారము నువ్వు వాపస్ పంపిస్తావు. వాపస్ పంపించి తిరిగి సక్సెస్ మళ్ళీ పంపిస్తాడు. నువ్వు అతను సైన్ చేయాలి. నీ డ్యూటీ అది. నువ్వు డ్యూటీ చేయకపోతే గవర్నర్ ఏం ప్రయోజనము? You are abdicating your function. That's all.
Thank you, sir. I asked one more question, sir, but have answered every question. That is post-retirement job, offering a post-retirement employment will create an influence over the pre-retirement.
అదే చెప్పినాను కదయ్యా. ఆమె ఎంత చూడాల వాడు రాయండి జడ్జిమెంట్ అంతా చూస్తే తెలుస్తుంది. అబ్బాయి, ఇఫ్ యూ peruse the previous judgment of that 1 year, it discloses that these people are pro-executive.
Thank you.
సార్ నాలెడ్జ్ అంటే నాలెడ్జ్ డివైన్ అనే అనుకుంటున్నాను. ఈరోజు తెలిసింది సార్ నాలెడ్జ్ డివైనే కదా.
పవర్
ఈ డివైన్ మా హార్ట్స్లో నింపేస్తారు.
Anyone? సార్, ఈ కాన్స్టిట్యూషన్ మీద మా బార్ అసోసియేషన్ టెస్ట్ కండక్ట్ చేశారు. కాన్స్టిట్యూషన్ మీద టెస్ట్ కండక్ట్ చేశారు సార్. అడ్వకేట్స్ తమని ఇప్పుడు సంతకాలు చేశారు సార్. వాళ్ళు పార్టిసిపేట్ సర్టిఫికేట్ తమ చేతుల ద్వారా తీసుకోండి. థ్యాంక్ యూ సార్.
The Madanapalli Advocates Welfare Trust takes great pleasure in announcing the names of the candidates who participated in the test on the Constitution of India. After careful evaluation, the prizes were awarded as follows. We earnestly request the Honorable Supreme Court former Judge Justice V.Gopal Garu to give away the prizes and the appreciation certificates. First prize is awarded to Sri Poola Sandeep, cash award 5,116. He scored 82 marks out of 100. With regard to this, Sitara Shopping Mall have come voluntarily to give some hamper gift hamper. Second prize is awarded to Sheikh Nafisa Banu, cash award 2,116. She scored 81 marks. She lost 1 mark difference. One more. Third Third prize is awarded to Mr. Abdul Rahman. Please come. సీతారా షాపింగ్ మాల్ వాళ్ళు ఒక చిన్న సన్మానం చేయాలని చెప్పి వచ్చారు. చిన్న సన్మానం చంద్రుడికో నూలు పోగోవాలి.
Okay.
Sir, following candidates who have enthusiastically participated in the test are awarded consolation prizes.
Thank you. Okay.
సార్ ప్రస్తుతం మీరు మదనపల్లి అడ్వకేట్ వెల్ఫేర్ ట్రస్ట్ మదనపల్లి అడ్వకేట్ వెల్ఫేర్ all the best. Do well. Janardhan,
Okay.
మా భారత్ నవాన్ బిహావ్ భారత్
Okay.
Thank you. Sarasa Vidyasagar, Satyanarayan sir, Yes, sir.
Okay, thank you.
High Court advocates, High Court and
They're
my bar members. All ladies. All ladies. Come first.
Okay, thank you.
All ladies.
Ladies, bar.
Randy. They want to have photo.
Please come.
Ladies can go.
Randy, please come. Photo. Your tribe must increase. Randy. Your tribe must increase.
కొంతమంది
Excellent.
Come. You also come.
Okay, Randy.
Oh, no, master. Come.
పొడుగుగా ఉండాలి ఫ్రెండ్ వచ్చేసారు మీరు ఎక్కడ Okay, thank you.
All the best. Do well. Okay. Please wait. The national anthem is there.
Okay, sir. Thank you.
Please sit down.
Okay.
5 more minutes, please wait. All of you take your seats. Participation certificates are to be distributed and thereafter the function will be concluded. Till then, request your patience.
Okay.
Now I request the distribution of participants. 10 minutes.
Give us Nehal authority, please come. Please follow with her, C. Sucharita.
Okay.
Sucharita. Miss G. Gayatri, please follow. Miss S. Pavitra. Mr. J. Uday Kumar. We count in here.
Okay.
Jahanavi Reddy. T. Haripriya.
Okay. Okay.
On behalf of the Bar Association Madanapalli, I have the honor to propose a vote of thanks to Justice V.Gopal, former Judge of the Honorable Supreme Court of India, for his enlightening lecture on the Constitution of India. My Lord clearly explained the growth of constitutional law by referring to landmark cases such as Gorakhnath, Keshavananda Bharati, and S.R. Bommai, highlighting the importance of Article 368, the basic structure of the Constitution, and the limited use of the Article 356. His explanation of legislative powers under Article 245, the three constitutional lists, and the role of judicial review helped us better understand how the Constitution controls the exercise of power by Parliament and the Executive. His Lordship also shared valuable insights on democratic governance, the role of the President and Governors, the 1977 elections, and the need to respect the mandate of the people. His concern about present-day challenges to democracy, the independence of the judiciary, and the electoral process gave us much to reflect upon. We were deeply inspired by his message that a strong bar ensures strong justice, and his call upon advocates to guide politics on the right constitutional path, just as lawyers did during the freedom movement, always through lawful and democratic means. We were equally touched by his respect for the Republic Day celebrations, his warmth in recalling past associations, his speaking a few words in Telugu, and his gracious reference to Sri N.T. Ramarao, which reflected his humility and love for the people of this region. On behalf of the Bar Association Madanapalli, I express our sincere gratitude to Justice V.Gopal Gowda for his time, wisdom, and inspiring presence. Thank you one and all. National anthem, please. Please stand.
Invited me to his place. I was a Supreme Court judge. And that day he decided he must make his son as a lawyer to follow my footsteps. He is really become a true son, and he is in Christ University at Pune. He is a wonderful boy. Father is enjoying his growth. Like that, all your children must be allowed to become great citizens of this country. Thank you very much.
National anthem begins.
जनगणमनाधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हिंद।
Okay, sir. Thank you. Stand. Next batch. యూట్యూబ్లో లైవ్ ఎన్ని రోజులు ఉంటుందా? డౌన్లోడ్ చేసుకోవచ్చు. అదే లింక్ అదే ఉంటుందా?
రెడీ పని సార్ రండి ఫోటో తీసుకుంటాం రండి అందరూ రండి నారాస్
ఓకే సార్ థ్యాంక్ యూ. నెక్స్ట్ సార్ పక్కన సార్ మొబైల్ ఓకే సార్ థ్యాంక్ యూ. ఇట్లే పెట్టచ్చు ఓకే సార్ థ్యాంక్ యూ. ఓకే సార్ థ్యాంక్ యూ. సాయంత్రం అవుతుంది. కంగ్రాచులేషన్ సందీప్ సార్. థ్యాంక్ యూ సార్. అక్కడ పోలా పొద్దున్నే ముఖ్యంగా మాకు కావాల్సింది అయ్యే చేసుకోకపోతే కొన్ని రోజులు చెప్పనా ఏం లేదు క్యాజువల్ ఇడి పక్కన
ముందుగానే చెప్పినాడు ఫోన్లో నేను మా ప్రకారంగా ఉండి ఫోన్ తర్వాత మీరు పోయి కలవచ్చు ఇలాంటి పని కాదు సార్ నేను వాళ్ళని ఏం అడగడం వల్ల ఉచితంగా అన్ని చేస్తాను
రాని వాళ్ళ గురించి సార్ వచ్చాం కదా వెరీ యూస్ఫుల్ చేశారు కదా హ్యాపీ వీఆర్ వెరీ
చేస్తాను